We are still at that order of business of bills on second reading, just saying. The next bill for our consideration is Senate File 96. Oh, that's right, privilege of the floor before we start. Privilege. Please.
Thank you, Mr. Speaker. Privilege of the floor.
Please.
Thank you. If you look up in the West Gallery, you'll see my beautiful wife and my two daughters, and is my older daughter Isla's third birthday today.
Welcome to the House and happy birthday. Representative Singh, do you have a privilege?
Thank you, Mr. Speaker. Privilege of the floor.
Please.
Ladies and gentlemen, if you'd look up to the South Gallery up here, you can go ahead and see my mom and dad, Jerry and Kathy Singh. I just wanted to introduce them to the House. I love you guys.
Welcome to the House. That's really awesome for House members to have some family here. It helps bolster the day, I can guarantee you. So thank you. With that, the next bill for our consideration is Senate File 96.
Senate File 96, sponsored by Water, Omnibus Water Bill Planning and Administration, an act relating to water development projects.
We have amendments. Chairman Nicholas. You need a copy of that, Chairman Nicholas. This is second reading amendment number 1 to.
Thank you, Mr. Speaker. I would move second reading amendment number 1 to Senate File 96 and ask for your favorable consideration. So, ladies and gentlemen, this is a technical correction that was brought to us by the good folks in LSO. Basically, what we're doing is we're identifying House Bill 93, which is referred to in this bill, and it ties the language back to that to make it more, to just clarify where that one-for-one match is inserted. So I'd ask for your aye vote.
Seeing your urge to vote, all those in favor of second reading amendment number 1 to Senate File 96 signify by saying aye. Aye. All those opposed? Second reading amendment number 1 to Senate File 96 has been adopted. Senate File 96, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 98.
Senate File 98, sponsored by Senator Barlow, Education, Certificate of Completion, an act relating to education.
Senate File 98, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 100.
Senate File 100, sponsored by Senator Barlow, Designation of Spouses, Revocation upon Divorce or Annulment, an act relating to wills and probate.
We have amendments. Representative Chestick.
Thank you, Mr. Speaker. I move second reading amendment number 1 to Senate File 100, and would urge an aye vote on this. This is a fairly simple amendment. I have 2 amendments, actually. They're separate topics, so I have them as separate amendments. The first one is simply trying to avoid some unintended consequences. The purpose of this bill is to correct a situation in which the spouses get divorced, and for whatever reason, their assets held jointly, either through the will or through other types of instruments, so the intent here is that if a spouse
they're divorced and then one spouse dies. These provisions that have not been updated might still allow the divorcee, the divorced spouse, the ex-spouse, to inherit, and this is intended to correct that situation. On page 6, line 10 of the engrossed bill, I wanted to insert a little bit more protection for the situation where there is a remarriage. The parties get remarried. The prior part of the bill would say that those other instruments kick back in, and therefore upon remarriage, it's as if they never were divorced. But I wanted to protect the situation in which prior to remarriage, there was some issue there. There may have, the parties may have still some distrust for each other, and they might actually have a prenup or some other agreement that they don't want these prior arrangements to kick back in. So just to make sure that there is the flexibility between the parties to opt out of that kicking back, of the prior things being kicked back in, I'm just adding some language that says that the prior instruments will not kick back in if they specifically have some kind of a written agreement that says they don't want that to happen. So just trying to make sure that there's not an unintended consequence, and I would ask for your aye vote on that amendment.
All right. Question having been called, all those in favor of second reading amendment number 1 to Senate File 100 signify by saying aye. All those opposed. Second reading amendment number 1 to Senate File 100 has been adopted. We are now on amendment number 2, second reading amendment number 2, Representative Chestick.
Thank you, Mr. Speaker. I move second reading amendment number 2 to Senate File 100 and ask for your favorable consideration. Another cleanup of potential unintended consequences. On line 7, page 4, there is some protection for banks or other parties who may not know about the revocation of the interest because of the divorce, and if they go ahead and act because they're not aware of that revocation, and they go ahead and act as if that hadn't happened, they are exempted from liability because they had no way of knowing about the revocation through the divorce. The question then is, if they do distribute according to the provisions that had been revoked, they're not liable for it, but I don't want that to create a situation in which the spouse, the ex-spouse who receives these goods or services or property from that third party, that because the third party is okay, they get to keep the stuff, they get to keep the property. So all I'm doing with second reading amendment number 2 is protecting the right of the injured spouse whose property was wrongfully delivered to the ex-spouse. They still have a right to go after the ex-spouse through some other mechanism, a lawsuit or other methods, to recover the property that should not have been transferred. So again, this is simply trying to make sure there is no, the spouse who received, the ex-spouse who received the property doesn't get a windfall, and that's all that this does. I ask for your aye vote.
Sensing your urge to vote, question having been called, all those in favor of second reading amendment number 2 to Senate File 100 signify by saying aye. All those opposed. Second reading amendment number 2 to Senate File 100 has been adopted. Senate File 100 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 107.
Senate File 107, sponsored by Senator Hicks. Acquisition, exchange, and sale of trust lands, an act relating to state lands.
Representative Western.
Thank you, Mr. Speaker. I would like to move second reading amendment number 1 to Senate File 107. So this amendment is a follow-up from the debate and the discussion that we had yesterday. Just to kind of refresh some of you folks, really the contention was, or one of the concerns, was that someone who is not close to this land, isn't adjacent to it, to this little 80-acre parcel or less, that someone from the other side of the state, or the country for that matter, could nominate this 80-acre parcel up to go through that sale process. And so this amendment is brought to kind of address and button up some of those concerns. And it does so in this way. What it basically means is that if you have a preferred right, meaning if you're adjacent to that land, that it gives you the ability to come in and match the highest bidder. So really, it's in those first two sentences if you read, shall give preference to a bidder who has legal access to the parcel to be sold prior to the parcel being placed for sale. A bidder who has legal access to the parcel immediately prior to the parcel being placed for sale may elect to purchase the parcel by meeting the highest bid of any other bidder for the parcel, or by bidding not less than the amount, the minimum price, et cetera, which is language that's found in the Constitution. So I think this allows those folks who have leased it or who have been next to it, who've been familiar with that property for decades or generations, that allows them to come in and make sure that somebody, again, from the other side of the state or the country doesn't swoop it up out from underneath them. So I think this amendment addresses those concerns, and please vote aye.
Representative Stith for your first time.
Mr. Speaker, on and against the amendment, I sort of understand what the bringer's trying to achieve. The problem, however, I think with the amendment is that it is giving preference to a bidder who has legal access to the parcel, right? So the problem that potentially creates is that in our Constitution, Article 18, Section 1 provides that any public lands that are disposed of shall be disposed of only at public auction to the highest responsible bidder. And so what this amendment does is it creates a situation where you chill the market for the land to begin with, because if I know that someone has a preference or a right of first refusal for, effectively a right of first refusal for an asset of some kind, then as a bidder, I'm not going to want to bid on it, because why waste my time if I'm the stranger, outsider? So your market of potential buyers is lower, so it reduces the value the state's going to get for it to start with. And by giving a preference to one person over others, it seems like what you're doing is not, it runs afoul potentially of Article 18, Section 1 of the Constitution. This is in contrast to state leases. Leases are slightly different. They're not constitutionally protected in the same way, and so we do give preference for leases. I think that is constitutional, and you do it for all sorts of practical reasons. But here we're selling state land, and it just seems that it creates a potential problem. So as much as I sort of empathize with the sentiment of it here, I just don't think it works. It's on and against. Thank you.
Representative Alaman for your first time.
Thank you, Mr. Speaker. I think this helps, but it's not the right answer yet, because we've seen this in the housing market. Someone come in from the West Coast with a lot of money in their pocket. The poor rancher can't match what he's willing to pay. I would like to see something like 120% over appraised value, or something more on that order. And I don't know that that's possible. Thank you.
Mr. Majority Floor Leader.
Thank you, Mr. Speaker. Just a curiosity question on ownership of the state lands. If this is an isolated piece of property within another piece of property, what are the responsibilities of the state to provide access? Is the state responsible if they sell that piece of property to someone other than who surrounds it? Is the state responsible to provide or pay for an access or create an easement to that piece of property and allow them to be able to get through it? Or is that the responsibility of the holder, because this is landlocked and they're going to have to force or a right by prescription to this isolated piece of property? Is the state responsible to provide access to their property, and do they have access?
Anybody else for their first time? Anybody for their second time before the sponsor? Representative Stith for your second time.
Mr. Speaker, just to address the majority floor leader's question, if in Wyoming, if you own a parcel of land that is truly landlocked, then and has no legal access, which could be the case if you're some stranger, you buy this landlocked parcel, then you're landlocked. There's a statutory procedure where you petition the county commissioners for the establishment of a private road. So there's a process for that, which, to be honest, makes the person who lives there, who was adjacent, who wanted to buy the land but didn't, unhappy, because that person essentially can force a private road. But that's our current law. And the current statute also provides for compensation for the fair value of the private road easement. But the state itself wouldn't have any obligation to, once it sells the land, has no further obligations. The new owner would bear the responsibility of establishing the private road.
Representative Nyman for your second time.
And therein lies Mr. Speaker, and therein lies my question in the fact that it can create a real wreck if the state's not willing to step up and to do something to provide access to this property. If they just arbitrarily sell this, then they just look at these folks, say, you guys work it out. The impacts that landowner that is surrounded it that can't compete, if somebody comes in and wants to, in a specific case I'm thinking of, is willing to pay $10,000 per acre for rangeland that is, really, it's no longer agricultural land. This has become what we call transitional land. And now it suddenly has such an increased value. But I guess that's my question in this. And that's the problem that we're creating is if we don't allow a potential for that landowner to be able to save themselves a potentially enormous legal battle to try to protect this or provide access to multiple potentially, then I think we're doing a real disservice. And I think the state has some responsibilities if we're not going to give you access or provide some means of getting to it, at least a right of first refusal to the folks that are going to be the greatest impact to. So I would support this amendment.
Representative Alaman for your second time.
Thank you, Mr. Speaker. This land would have to be sold at auction if I believe that to be true. So if it was sold at auction, maybe that guy from the West Coast wouldn't be paying $10,000 an acre. Maybe he's going to be paying just $100 over where you stopped. Would you still be able to meet that bid? Thank you.
Representative Western for your second time.
Thank you, Mr. Speaker. So a lot of ground covered, and I'll try to do my best to answer most of it. To the good gentleman from the rancher in the center part of the state, this amendment gives that ability to that rancher to come in. So let's just kind of walk through what a scenario would look like. Under that $10,000 an acre scenario, someone from the West Coast nominates this land for sale. They're allowed to come in and place a bid. They do $10,000 an acre. If it's an 80-acre chunk, that's $8 million. This amendment allows that person who surrounds that 80-acre parcel to come in for the final time and say, we're going to do $8 million or $8 million and $1. I think we also kind of need to think through the practical implications here. So you're telling me that there are a couple of exceptions in the state, specifically the county with the sharp mountains. But outside of that, just if we think through this practically, it's pretty unlikely that there's going to be someone who's going to pay $8 million for that 80-acre parcel when they know that, well, if I do buy this, God, this rancher surrounds that entire land. I'm going to have to deal with them and have to negotiate with them, condemn right of private action to get a road through there, all that stuff. It is just not worth the headache, right? That $8 million, heck, I might as well just go buy 1,500 acres closer to the mountains that I'm going to get way more bang for the buck, and I'm not going to overpay of an incredible magnitude. So I think we have to think through it practically. Like, is that scenario impossible? No, but highly unlikely. Again, especially if you exclude County 22 in that type of scenario. The attorney from where the water is sweet mentioned some constitutionality concerns, and that potentially this amendment would chill or reduce the bidding pool potentially of those folks because they know that there's somebody else can come in. I would say not necessarily, right? Someone who is well-heeled and can hire good attorneys to walk them through this process can understand that they came in at a good number, that there's a decent odds that they might still get it. Again, these are just these 80-acre parcels, not the big contiguous ones that are thousands or tens of thousands of acres. And I would push back in the constitutionality. Again, it still allows for anybody to come in, any bidder. We're not excluding bidders from the bidding pool. We're allowing any bidder to continue to follow this process to come in and make a bid. All it simply does is saying once that highest bid has been placed, it allows that the person who owns the land surrounding it to come in and equal or potentially increase that bid, have that final option. So we're still optimizing or maximizing revenue by not excluding any bidders from the bidding pool while adhering to the fiduciary responsibilities for the beneficiaries, but also making sure that the rancher who's been leasing that land or using that land for generations doesn't get the rug yanked out from underneath them, and they have an ample opportunity to make sure it doesn't slip away from them. So I hope that answers some of your questions. I encourage an aye vote. Thank you.
All those in favor of second reading amendment number 1 to Senate File 107 signify by saying aye. All those opposed? Second reading amendment number 1 to Senate File 107 has failed. Division having been called, all those in favor, please rise. Guess he's down. All those opposed, please rise. Thank you. Second reading amendment number 1 to Senate File 107 has failed, 24 to 25. Senate File 107, we got another one? I don't think I have another one here. Oh, yeah, I did. All right. Chairman Eklund.
Mr. Speaker, I move second reading amendment number 2 to Senate File 107 and would ask for your favorable consideration. So this is a little bit different. On page 2, line 8, after 1999, insert leaseholder of the state trust lands shall have a right of last refusal regarding the sale of the state trust lands by matching any bona fide offer made by a third party. So the reason I bring this is if we're leasing, transferring leases or bidding on leases, this is a provision that's allowed the leaseholder. And I think it's allowed and is done in consideration for the leaseholder has been the caretaker sometimes for generations, and that's what the state has done. I don't think there's a huge difference between the two. We're going to hear the same arguments on constitutionality, but it's my understanding that maybe this is constitutional. Since it hasn't run through the court, we don't really know that. But I do think that this provision in the bill will make it easier to pass, and I think it's a fair insertion to put amendment to put in the bill to try to make this bill work. Because what we're trying to do is consolidate a bunch of tiny chunks of land, and we may not get it done. This bill could fail if we don't find some common ground. It's my hope that this will be the common ground we can use to get the bill to pass.
Representative Storer for your first time.
Thank you, Mr. Chairman. I realize I'm going to show my age by telling this story, but I actually did serve on a state trust lands task force in the mid-1990s, appointed by Governor Geringer at the time. And just to rewind the clock.
No names.
Oh, sorry. A former governor. And it was at a time when the state was suffering from budgetary shortfalls. And there was a lot of pressure to sell state trust lands at the time. And they were being sold, and they were being sold with the right of the lessee to meet the high bid. So that and many other issues were actually becoming quite contentious at the time. So the former governor put together a task force. I served on that. And we put together a report that I think had a lot of good recommendations. And much of that resulted in legislation that was brought to this body in 1997 and passed. And one of those provisions was to take out the right of the lessee to meet the high bid, because it was clearly identified as something that was not constitutional due to Article 18, Section 5, that says no special privileges may be allowed when it comes to the sale of state lands. So similar to the former proposed amendment, this amendment as well really goes against the Constitution because it does not allow for a public auction as required. So I am sympathetic to the idea that we're trying to make these lands more manageable, more valuable. I do think there are ways we can do that. I know this has been a conundrum. And I would just encourage this body to work on this in the interim, especially in terms of presenting, working on the idea of exchanges that can increase public access as well. So thank you on and against the amendment.
Representative Banks for your first time.
Thank you, Mr. Speaker. I appreciate the good chairman bringing this amendment because it addresses the concerns that I had yesterday about this particular bill. And using that scenario that I used of the leaseholder or the rancher who has this particular 80-acre piece in the middle of his ranch. And then it gets nominated for this program by one of these people from a coastal state or something to use. This gives the ability of that leaseholder who's taken care of it for the past 20 years to be able to match that and be able to have the last say in the dollar amount. I think that's the protections we need for our landowners so that the rug's not just pulled out from underneath them. We heard some things about constitutionality. This doesn't take away from that. This, after the bid is placed, this doesn't say that we're throwing that out the window. It gives the current leaseholder the ability to match whatever that is. So we're not taking away the value that comes from the piece of property. We're giving the leaseholder that one final chance, which I think he's earned that right of taking care and being the caretaker of that property for sometimes decades. So I appreciate the good chairman taking the time to address the concerns some of us had about this bill, and I urge an aye vote on this amendment. Thanks.
Representative Western for your first time.
Thank you, Mr. Chairman. Basically, same amendment, take two. Although I do think this strengthens it a little bit better because it specifically mentions the leaseholder. And to the gentlelady from the land of Sharp Mountains, they talked about these special privileges. And the Constitution that specifically is referencing folks who have settled upon that land. And so to read the part from Section 1 where I think that illustrates that this is constitutional, it says such lands shall be disposed of only at public auction to the highest responsible bidder after having been duly appraised by the Board of Land Commissioners at not less than 3/4 the appraised value thereof, and for not less than $10 per acre, etc. So again, we're not excluding anybody from the bidding pool. We're not making this a semi-public. I mean, it's pretty clear. It needs to be public. Anybody can come in and bid. All we're simply saying is that once that process is happening, we are allowing the leaseholder come in and match or exceed that bid. Again, maximizing revenue on behalf of the beneficiary, our schools. So hope that provides some clarity.
Representative Slago for your first time.
Thank you, Mr. Speaker. On and for this amendment, agreeing with our majority floor leader on his comments from the previous amendment, this is be a valuable amendment because it does allow the current lessee to get that. And the big problem we need to remember, going back to when we discussed this bill yesterday, these are landlocked 80s or smaller. And so they're ones that have no public access. And so for people to come in and do that, then like was talked about earlier, we do have the issue of them getting access in there. And so then that would constitute a taking of somebody's private land for them to get access into this land that's being sold. And so I think this idea of allowing the current leaseholder to match or go over the highest bid is a good deal. Thank you. On and for.
Chairman Washit for your first time.
Thank you, Mr. Speaker. Maybe I'm missing something here, but I think the operative word is landlocked. And so it would seem to me that a landlocked parcel is not going to be all that attractive to outside bidders because they're going to still have to come in and negotiate for some access unless they're going to helicopter into their land, right? So it seems that perhaps the value of that property is greatly diminished because it is landlocked. And thus the leaseholder is probably the one who's in the best position to offer a reasonable bid for that property. It might even get a great price on that property.
Representative Bear for your first time.
Thank you, Mr. Speaker. I would challenge the good chairman of judiciary because I do believe that there are laws that require you to provide access, and that's where we get into easements. And the previous speaker to him mentioned the risk of takings. And I do believe this is a good common sense amendment for that reason. We can allow the person who's been taking care of the land, who's likely the person who surrounds the land, to ensure that they have a good opportunity to make their land whole. As we look at the new people coming into our state who don't have access to land to hunt on because generally speaking, most of the land is purchased up and there's not a lot of land available at a reasonable price anymore that hunters can go to. So these lands are lands that hunters would like to get to. We as a state have got to come up with a policy that allows us to have our public lands accessible. These are lands in this bill that are not accessible. And so this would allow us to move closer to a plan where a landowner that has landlocked public ground can trade that out for something that's more accessible to the people who are not able to purchase land. I think this is a good common sense amendment. It will speed up the process of eliminating these pieces of ground that are landlocked, and it's a serious problem in our state. So on and for the amendment, and I would urge an aye vote.
Representative Crago for your first time.
Thank you, Mr. Speaker. I just try to bring a little bit of clarity back to the discussion on what kind of parcels we're actually talking about. And this was a source of debate actually within the committee. So if you look on page 3, it defines the parcel, right? Isolated parcel means a parcel of state trust land surrounded by non-state lands and without public access to the parcel. And so that doesn't have to be an isolated piece of land out in the middle of nowhere. It could be a piece of state land, and I think the good majority floor leader talked about this first time. It could be a piece of land where the county road runs right through it, as long as it's surrounded by non-state land. It also could be surrounded by BLM land, federal land, or other types of federal land, up in the forest, for example. And because those don't necessarily have public access to begin with. They could gather public access. You could pay for an easement to travel through federal land, but it doesn't have one to begin with. And so I think any of those could qualify as isolated parcels, which is one of my concerns. It's a lot of parcels and it's in a lot of different areas. And so I think it's not necessarily the ones we're all thinking about out in the middle of nowhere necessarily, required to be surrounded by private land. Also, and I think the good representative from Campbell County mentioned this a minute ago, there really is no such thing as landlocked private property in Wyoming. You can always bring a private road action and get access. You just have to pay for it. And if you can't agree with the surrounding landowner or the private landowner, you bring an action, the court decides where it goes, and you pay whatever market value is for that easement through the private property. And so it's not really a condemnation. It's similar to a condemnation type action, but you get paid for it whatever the private prevailing market rate is at that time. So hopefully that helps everybody a little bit.
Representative Stith for your first time.
Mr. Speaker, I think the good chairman of judiciary is correct that if it's a landlocked parcel, it's not going to be worth as much as a parcel that's got access to it, but it's still worth something, right? And the representative from District 40 is also correct that there is a process. If you own or acquire a piece of landlocked property, there's a process to establish a private road, and you can do that. So on and against this amendment, because it suffers the same problem, that it does run afoul of Article 18, Section 1 of the Constitution that requires that the land be sold to the highest bidder at a public auction. So that's again, the problem, and by having this amendment, again, you chill the market, and so the state would be getting less money for its property. So on and against, thank you.
Representative Yin for your first time.
Thank you, Mr. Speaker. So just to reiterate, I think it is a good policy decision. I think it's a good policy decision to allow folks who have managed this land to continue being able to manage it by being able to purchase the land. But, I think our first responsibility is to our oath to the Constitution. And so I think, unfortunately, it is explicitly very clear that it has to be sold to the highest responsible bidder, not a person who makes an offer that matches the bid. It's to the highest responsible bidder. So I think, unfortunately, you should vote against this amendment because I think it is unfortunately plainly unconstitutional.
Anybody else for their first time? Representative Nyman for your first time.
Thank you, Mr. Speaker. On and for this amendment, when you stop and think about value and what this would generate, I can't tell y'all how much it's worth to a landowner that's got a piece of property that's landlocked to keep that from turning into a subdivision, which we're going to chat a little bit about, and the fencing issues that go with that in the middle of their property. So to say that it's going to be devalued, I understand that, because if you've got something with a first right of refusal, sure, it is. But landowners like myself and others, and for those that say it's just for, anyway, we won't even go into that, but it is critical for us to try to protect that piece of property and try to reduce the impacts that a situation like this would present. Because again, we're talking about all the issues you go through when somebody forces a road through you. I've had that happen. Attorneys make a lot of money. Roads don't always go where it's ideal. They have appraisers, finders, all these things come tumbling down the hill in this situation. So this is a good amendment. I appreciate this, as the last one. I think this would be comprehensive. This is not the end of it. We're going to need to continue to work on this because people want access to these pieces of isolated public lands or state lands. But this will resolve a lot of the problems moving forward and will help landowners pay really an exorbitant amount to protect what they're going to have to do. I mean, and another point here that I think needs to be made, what happens in this, then there's fencing costs. I had a situation where I dealt with some people that they lost a particular piece of land. The state is not responsible to fence, so the landowner had to come in and pay half of it. Because of the terrain in that particular situation, it ended up being almost $60,000 a mile to build fence in there that he had to share the cost of. So that has to be taken into consideration as well. I will pay a lot more for a piece of land if I don't have to pay that kind of money to try to fence it out or pay my half of that fence. So on and for this amendment.
Representative Pendergraft for your first time.
Thank you, Mr. Speaker. On and for the amendment. Regarding the constitutionality, I believe, first of all, this is a very good common sense response to this issue. And it's my understanding that until something is adjudicated, we may not actually know. So I would urge an aye vote. Let's do this. If there's a problem, they'll sort that out. But in the meantime, I think we would risk possibly doing a good thing.
Anybody else for their first time? Anybody for their second time before the bringer of the amendment? Chairman Eklund. Too late.
Mr. Speaker, so we've had some conversation on how this might drive the cost of the land down. And I believe if you have the first right of refusal built into there, you may drive the cost of the land up from the appraisal value, because they know whoever's bidding on it knows at the end of this, the leaseholder will have the final bid. It could be driven up over, in fact, could drive it up scary high. So I don't know if that's a great argument, and I'm not sure how it would turn out in the court system. We've heard several reasons why it shouldn't affect the value of the land. And I think this is a way of maybe making this bill work. We're trying to block up some state lands, make these trust lands more valuable. As they are, they're just less valuable to the state. So looking at it that way, I do believe that if this amendment were to pass, it might make this bill palatable and get the bill to pass too. So with that conversation, I would appreciate an aye vote on this amendment. Call for the question.
All those in favor of second reading amendment number 2 to Senate File 107 signify by saying aye. All those opposed? Second reading amendment number 2 to Senate File 107 has been adopted. Senate File 107, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Privilege of the floor, Representative Provenza.
Thank you, Mr. Speaker. I would like to introduce to you my predecessor. I think that's the right word. Words are hard at this point in the session. But all of the representatives for House District 45 have been tremendous and been tremendously tall. So I would like to introduce Representative Charles Pelkey.
Hey!
Well, it's good to see you guys. I just stopped by. Governor signed a bill that was particularly close to my heart, the childhood marriage amendments, and that's passed now. So I thought I'd come out and say hi. I'm glad to say hi to you guys. And Representative Provenza is right. There's a minimum height requirement to run for House District 45. You must be this tall to enter this ride. And it is a weird ride at times. So, you know, being a Democrat in the Wyoming House of Representatives is an uphill battle. So I guess you have to have a little bit of oomph behind it when you do run. But anyway, it's good to see you. I've been following you on social media and occasionally tap in and listen to the floor debates, and then I suddenly turn it off again just because I have other things to do. But good to see all of you. A lot of new faces around here, and a few old ones. So it's good to be here, and I hope everyone's doing well. I guess you're done a week from tomorrow, so drive carefully when you go back home.
Representative Pelkey, welcome back to the House, and it's really good to see you upright and doing well, and we appreciate, Representative Pelkey, your struggles with your health over time and how you've handled that. It's a real inspiration to the rest of us. So.
Yeah, just don't follow my lead. I had 4 major surgeries over 2 months. I think I spent 16 hours under the knife total, but I can walk again, so. I just want to make a note. There are 3 members, or 3 of us, who got elected to the Wyoming State Legislature from the class of 2009 from the University of Wyoming Law School. Apparently, one of them is here giving the fist bump, and I'm going to go over to the Senate side and say hi to Senator Nethercott as well. But as we were a bunch of miscreants, we were among some of the most hated classes in the University of Wyoming College of Law. At least our contracts professor thought so. But you know, 3 of us managed to get elected to the legislature, and I'm really, really proud of that. So take care, you guys.
Thank you. Take care. The next bill for our consideration is Senate File 113.
Senate File.
Oh, I got one more privilege, I think. Privilege of the floor, Representative Sherwood.
Thank you, Mr. Speaker. To your right, on my left, up in the gallery here, you will see a group of fierce Wyoming women who are participating in Leap into Leadership, learning how to run for office today. So hello and welcome, ladies.
Welcome to the House, Leap into Leadership. That was a great event last night, very inspirational. So thank you folks for dropping by. With that, the next bill for our consideration is Senate File 113.
Senate File 113, sponsored by Senator Pappas. Architects Practice Act Amendments, an act relating to professions and occupations.
Senate File 113, having been read 2 separate times, the question is, shall the bill be read a 3rd time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 116.
Senate File 116, sponsored by Senator Doc Stater. Protection of lawful commerce and firearms, an act relating to civil procedure.
Representative Allred.
Thank you, Mr. Speaker. I move second reading amendment number 1 on Senate File 116 and ask for your favorable consideration. This was a little typo that our good people from down the hall brought to me during the lunch hour. And if you look on page 2, line 13, engaged is now changed to engage. And on page 4, line 12, insert D instead of C in the parentheses, just a little technical thing. Thank you.
All those in favor, question being called. All those in favor of second reading amendment number 1 to Senate File 116 signify by saying aye. All those opposed. Second reading amendment number 1 to Senate File 116 has been adopted. Representatives Wanitzer Dave.
Thank you, Mr. Speaker. I move second reading amendment number 2 to Senate File 116 and ask for your favorable consideration. Members of the body, this bill, as you know, is trying to give some exemptions to manufacturers of firearms. And for those of you who tend to love your firearms and put together firearms with different parts in your basement or out in your shop, what I'm attempting to do here is to give you also an exemption if you buy it from a particular manufacturer and you decided to remodel it or enhance it, or you're one of those great gunsmiths that's able to put 3 or 4 different manufacturers' guns together that function operatively, to also give you this exemption should that need happen. And so they obviously go after the manufacturer, but if you happen to put a piece onto it and enhanced it or whatever, this hopefully will give you some sort of an exemption also.
Anybody else? Chairman Newsom.
Oh, just a question. Thank you, Mr. Chairman or Mr. Speaker. Why the 10-year increment of gunsmithing? What was the thought process?
Representative Bear.
I too have that same question. It just seemed to me, and maybe I'm misreading it, I would just like some clarification, because I don't want to exclude young people who have not had an opportunity to get 10 years of experience from being a partaker in this opportunity.
Anybody else for their first time? Representative Ward for your first time.
Thank you, Mr. Speaker. I also have a question regarding those 10 years. How do we determine that a person has had 10 years of experience?
Anybody else for their first time? Representative Pendergraph for your first time.
Thank you, Mr. Speaker. Again, the 10-year thing is rather confusing. I don't remember how long an armorer in the United States military has to go to school, but coming out of there, they're able to do just about anything with that weapon. What is it? Perhaps you could explain later. It's nowhere near 10 years. This is not rocket science. The 10 years is unreasonable.
Representative Angelos for your first time.
Thank you, Mr. Chair. Speaking that this is my husband's profession, he is self-taught, did not take that many years to, there's no journeyman license as a gunsmith. You can go to school, you cannot. There's no regulation on that. There's plenty of regulation through the department that handles our guns and may have the word fire in there, but there would be no way to even determine this, honestly. Thank you. Against the amendment.
Representative Alaman for your first time.
Thank you, Mr. Speaker. Gunsmithing course is about 1.5 years, professional one. So this 10 years is a little out of line. I like the thought of the bill other than the 10 years. I think we need to clean that up though. Thank you.
Anybody else? Representative Davis, you're working through the woodwork. Is that Representative Davis?
Thank you, Mr. Speaker. The bringer of the amendment, I have a question. My grandson and I bought him a black powder pistol, and we put it together last winter in the garage. Is that a violation if I'm following this correctly?
Representative Stivar for your first time.
Thank you, Mr. Speaker. The Army course is 16 weeks.
Anybody else for their first time? Anybody for their second time before the sponsor? Representative Swanitzer Dave.
Thank you, Mr. Speaker. I believe the old guns and the antique firearms are already in that bill as being exempt. And so my whole purpose was to, if you live in Wyoming, to have this exemption. And the 10 years I just pulled out of my hat. And because I thought, well, if I don't put some sort of, it says you're a Wyoming resident, but then we have this argument, how long do you have to be in Wyoming to be a resident? So I have no heartburn with the 10 years or whatever. I'm just trying to protect those people. And apparently we have more than one or two in the audience that would like to have some of those protections. So when you get into those court cases, they don't come back on you because you modified or adjusted the firearm. So either way, I'm happy to talk with anybody to get them another amendment for third reading. And that's why I brought it on second reading, to see what the body felt. Thank you.
All those in favor of second reading amendment number 2 to Senate File 116 signify by saying aye. All those opposed? No. Second reading amendment number 2 to Senate File 116 has failed. Senate File 116. See, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 128.
Senate File 128, sponsored by Senator Hicks. Transfer of state lands, exchange, an act relating to state lands.
Senate File 128, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 131.
Senate File 131, sponsored by Senator Hutchings. Prohibition on delivery of unsolicited ballot forms, an act relating to elections.
Representative Yen.
Mr. Speaker, I move second reading amendment number 1 to Senate File 131 and ask for your favorable consideration. So members, this is a fairly simple amendment. Basically, all it does, if you read it in, is that it allows for no person shall distribute a form that is likely to be confused as an official election document. So this broadens it out a little bit to not just identify the absentee ballot request form as something that seems like it could be confusing when sent out by individuals, but anything where they're pretending to be an official election document. So with that, that's all it is. It just broadens it a little bit to cover more types of documents, so you can't pretend to be something from the clerk or the Secretary of State. And I ask for your favorable consideration. Thank you, Mr. Speaker.
Representative Singh for your first time.
Thank you, Mr. Speaker. I'd like to call upon the Rules Committee to talk about the germaneness of this amendment.
Rules Committee to the front. Representative Singh, you're going to have to come up here and to the mic, please. So after the Rules Committee met, it was determined that the Rules Committee voted that this amendment is germane, is within the scope of the bill. And so Representative Singh, your alternatives is to withdraw your protest or your point of order, or you can go to the body and ask for their ruling. So Representative Singh.
Thank you, Mr. Speaker. After much consideration, I withdraw my point of order.
All right, so we're back on the motion, which is the amendment, and somewhere is Representative Yen. Oh, all right, there you are. Representative Yen.
Speaker, I'm sorry, I tried to get here, but I couldn't.
So we're on an amendment, Representative Ward. Okay.
Mr. Speaker, I was finished with my first time. Thank you.
What's that?
I was finished with my first time speaking.
Okay, you
on the
were?
amendment.
All right. Thank you. Representative Ward.
Thank you, Mr. Speaker. I'm sorry for interrupting there. Just wanted to make sure you saw me. My question is, what is likely to be confused mean? Supposing I'm just a voter and I print out a ballot and I mark the little ovals to bring in with me to vote with because I can't remember everybody on the ballot. Is that considered in violation of this amendment? Also, the purpose of this law was, or this bill, and then this amendment in connection, was to prevent what looks like an absentee ballot request from being sent out by someone not a part of the government. And I think this amendment, I'm on and against this amendment. This amendment destroys the purpose of the bill. Thank you.
Representative Hornock for your first time.
Mr. Speaker, I'd like to divide the amendment.
Please proceed.
The division will be lines 1 through 4 as Division 1, and then lines 5 through 7 as Division 2.
Chairman Zwanitzer, I'm going to get you up here too to help me dissect this. Yeah, I'm good. I'm good. Yep. So Representative Hornock, it's divisible. I'll be honest, earlier this morning, I made a mistake on that other one because it was divisible, but they didn't stand on their own. So the only way this can stand on its own is if we start with Division 2 first. And so Division 2 is where you would start. Representative Hornock, for your first time on Division 2.
Thank you, Mr. Speaker. On Division 2, I think this is an important piece of this particular legislation because we're dealing with the assumption of what the document is. And I think we need to keep that in there. Regardless of what we do with the Division 1, I think we need to have something that deals with an assumption of what's going out in the mail, whatever the document is, we'll deal with that with Division 1. But when I receive the mailer in the mail, what do I assume that is? Do I assume that is from an official thing, or do I just, do I not? And so I think it is important with the bill itself to have something in there where we're dealing with something that does claim to look official, so that it's not just something scribbled, anything can, you're talking about taking a official ballot election form, something, tailoring a mailing to look like that type of thing with the intent of confusing, or not the intent, frankly. You can actually do that accidentally even and confuse a voter and say, hey, this is what I need to fill out and go turn it in. And then it's not actually official. So I do think that that we need to keep something in the hands of our clerks and our election officials, and any mailings, anything to the otherwise with that somebody running for office is mailing out, then I do think that they need to stay a little bit away from those official type of documents. I urge a aye vote on Division 2.
Representative Provenza, nope. Okay, anybody else on Division 2? Representative Yin? All right, all those in favor of Division number 2 on second reading amendment number 1 to Senate File 131 signify by saying aye. All those opposed? No. Division 2 has failed. We are now back on Division 1. Representative Hornock.
So Division 1, I think, is actually now important to keep in there, since we voted against Division 2, because we're dealing with a specific type of document. I urge a aye vote on this one too.
Representative Yin.
Mr. Speaker, thank you. So I would still urge an aye vote on Division 1. I think even without adopting Division 2, while Division 2 kind of makes it a little bit more specific and actually might help reduce that confusion element, I think that actually might end up working out. So I guess I urge an aye vote on Division 1 or Division 2.
Division 1. We're on Division 1, Representative Yin.
Division 1. Thank you, Mr. Speaker, for that correction.
Anybody else on Division 1? Representative Ward on Division 1.
Thank you, Mr. Speaker. I urge a no vote on Division 1 for the reasons I stated previously. What if I, as a voter, go into the ballot area with a ballot filled out because I want to try to remember who to vote for? Is that likely to be confused? Supposing a candidate passes out a ballot that's filled out to encourage voters to vote a certain way. I think that ought to be allowed. This bill, what it does is prevent absentee ballot request forms from being sent by non-governmental agencies. I urge a no vote on Division 1.
Representative Bear for your first time.
Thank you, Mr. Speaker. I too urge a no vote on this division. I had a longtime legislator tell me one time that if you wanted to create good law, you needed to do a rifle shot instead of a shotgun approach. And that's exactly what the bill does prior to this amendment. This amendment opens it wide open, and this is like an open choke on a shotgun. It's really covering far too much. I think the bill was very specific and addressed a very specific concern, and I think it's appropriate to vote no on this division and keep the bill as written.
Anybody else for their first time on Division 1? Representative O'Hearn on Division 1.
Thank you, Mr. Speaker. It says in line number 1, I believe, that it's prohibited from distributing these forms and absentee ballots. If you print one out on your own computer for your own sake and carry it into the ballot box, I don't think you would be precluded from doing that. Thank you.
Anybody else for their first time? Anybody for their second time? Before the divider, Representative Yin for your second time.
Thank you, Mr. Speaker. So just to reiterate again, so something that could be confused and then would claim to be an official election document, for example, would be if someone was distributing actual absentee ballots, and this would still help prevent that. So not only would it prevent the request forms that could be confused as real request forms and claim to be real request forms, it could also cover absentee ballots that third parties try to put out. They claim to be actual absentee ballots. This would cover both of those. Vote aye. Thank you, Mr. Speaker.
Anybody else for their second time before the bringer of the division? Representative Hornock for your second time.
Thank you, Mr. Speaker. So I was a little bit confused on the first when I spoke before. Actually, during the Rules Committee, there was a point made by the good representative.
What we do in the Rules Committee, we're not going to repeat here.
Yeah. Okay.
Okay.
Yes. One of the points made me bring this division because it was something that was valid. So we're dealing with a lot of potential official documents here. So I think that's important to get correct in the bill. I do urge a no vote on this division. Thanks.
All those in favor of Division 1 on second reading amendment number 1 to Senate File 131 signify by saying aye. Aye. All those opposed? No. The Division 1 has failed. We are now on second reading amendment number 2. Representative Chestick.
Thank you, Mr. Speaker. I move second reading amendment to Senate File 131 and would ask for your favorable consideration. This is another cleanup. It's a guardrail, as I would call it. We hear a lot about voter suppression, and I don't want anybody to look at this bill and think this is an attempt to suppress votes. And the way I think we can ensure that this is not a voter suppression attempt is to clarify that although a person who's not the elector cannot seek to have the absentee ballot delivered to the elector, only the elector can do that, there are ways in which other people can encourage people to seek absentee ballots and to help them get their own absentee ballots. We do a lot of voter registration drives and other kinds of activities to encourage voting, which we should do. And therefore, my amendment simply clarifies that if somebody is trying to help an elector get their ballot, They're not violating this section of the statute. You are allowed to help other people request their own ballots. And therefore, I would ask for an aye vote on this amendment.
Representative Ward for your first time.
Thank you, Mr. Speaker. My question about this amendment is, who is an individual? There was an individual who made national news recently, whose name began with Z and then ended with Bucks. So this individual spent a lot of money nationwide to do voter registration drives. For that reason, I am on and against this amendment.
Anybody else? Oh, Representative Penn for your first time.
Thank you, Mr. Speaker. I would urge a no vote on this. I think this bill is already very clear. It's only 5 lines long, and the amendment is longer than the bill itself. There already isn't anything in here that would cause that confusion, and I think it's unnecessary. Please vote no. Thank you.
Representative Bear for your first time.
On for a second, first for a second.
Representative Singh for your first time.
Thank you, Mr. Speaker. I would urge a no vote on this. I think this adds too much language and overcomplicates the original intent of this bill. Thank you.
Representative Locke for your first time.
Thank you, Mr. Speaker. First for a second.
Anybody else for their first time? Representative Allemand.
Thank you, Mr. Speaker. I also first for a second.
Anybody else? Representative Larson Lloyd.
Thank you. First for a second.
Any other first for a second? Representative Provenza.
First for second, Mr. Speaker, thank you.
Representative Henderson.
First for a second, Mr. Speaker.
Representative Sherwood with trepidation.
Mr. Speaker, this amendment seems to encourage voter registration drives. I'm wondering where the disconnect is that we aren't all getting behind this and encouraging our electorate, our potential electorate, to be more engaged citizens. Thank you.
Anybody else for their first time? Anybody for their second time before the bringer? Representative Hornock for your first time. No, that's your first time.
Yes, thank you, Mr.
Okay,
Speaker.
sorry about that.
It's all right. The section that we're dealing with in the Green Books right here deals specifically with absentee voting. So it talks a lot about what to do with how absentee ballots are supposed to be made and it just every nuance of absentee ballot that you'd ever want to know. This section of the Green Book deals with that. It does not deal with what this amendment talks about. So I don't really think this amendment needs to be in this section of the Green Book. Thank you.
Representative Yin.
Thank you, Mr. Speaker. It explicitly talks about encouraging qualified electors to obtain an absentee ballot or otherwise educating qualified electors on how to obtain an absentee ballot. I think it is relevant to make sure that it's not infringing on those rights to create those educational programs. And again, it's very confusing on why this is controversial at all. I don't understand why we wouldn't want to teach our electorate how to vote. So thank you, Mr. Speaker.
Anybody else for their first time? Anybody for their second time? Representative Ward for your second time.
Thank you, Mr. Speaker. I think the question centers around who is an individual. The individual whose name begins with Z and was referred to as that Z Bucks
Not again.
spent $400 million doing this, and it affected our elections. Thank you.
Representative Bear.
Thank you, Mr. Speaker. I apologize earlier. I was just really trying to think through this. I don't believe this is germane, so I'd like to call a Rules Committee on germaneness.
Rules Committee to the front.
Okay, the House will come to order. All right, the Rules Committee based upon the Rules Committee recommendation, I find that the amendment is germane, and we've gone through, people had spoken once, people had spoken twice. Anyone wanted to speak on this amendment for the second time? To the sponsor.
Thank you, Mr. Chairman. As has been said before, I won't be long here. This bill is simply encouraging people to learn how to vote by absentee, and we should be encouraging voting, and for that reason, I ask for an aye vote.
All right, you've heard all those in favor of second reading amendment number 2 to Senate File 131, say aye. Aye. Those opposed? No. Second reading amendment number 2 to Senate File 131 has failed. Division being called. All those in favor of second reading amendment number 2 to Senate File 131, please rise. Okay. All those opposed, please rise. More than 24. Senate File 131, having been read 2 separate times, the question is, shall the bill be read a third time? Oh, we have another amendment. Representative Ward.
Thank you, Mr. Chairman. I respectfully withdraw my amendment.
Senate File 131, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 137.
Senate File 137, sponsored by Senator Steinmetz. Subdivisions, fencing requirements, an act relating to planning and zoning.
I don't need to. We have amendments. Representative Brown.
Thank you, Mr. Speaker Pro Tem. I move second reading amendment number 1 to House or Senate File 137 and ask for your favorable consideration. Ladies and gentlemen, you'll remember our lengthy discussion about fences yesterday. And, you know, I learned a lot more about fences than I probably care to know in our state law. And it's kind of crazy that we actually have an entire section of our state law in Title 11 in Chapter 28 that is dedicated to nothing but fencing. And I worked with the Good Country lawyer to actually try to make this a little better than what we had come over here. And I'd say this is a compromise because my original amendment, you'll notice that this is the corrected copy. The original amendment that I had drafted was basically just going to take 1128-101 through 1128-108 and just plug that in and just say that's what the lawful fences are. What we've done with this is the amendment looks a little goofy, but ultimately I'll give you the understanding of what we're trying to do with this. And if you look at on lines 5 and 7 here of the amendment is really where we get to the meat of this discussion, and that is that a lawful fence as prescribed by 1128-102. And that's going to be in there on page 2, lines 14 and 15. And what we're trying to say with that is when you are building a fence that is considered a lawful fence, that's all of the stuff that you see inside of the, it needs to be this many feet deep and this many inches wide and all that stuff. We're really literally just cleaning that out of there. And that's why you see line 17 through 23 on page 2 and then page 3 being deleted entirely. And then we kind of clean everything up out to page 4. And then what you see on page 4 is the reconstruction or the construction costs of the fence. And this is where the compromise really came into play. And I'll say that I'm not completely happy with this, but I do want to say that I appreciate the Good Country lawyer as well as a couple of the organizations that are supporting this particular piece of legislation working with me on this. And it just, I'll read it to you exactly how it says it and then kind of explain the intent. And it says, provided that the adjoining landowner shall be responsible for half of the costs of maintaining the perimeter fence not to exceed the reasonable cost to maintain the fence if the fence was underneath 1128-102A1. What does that mean? Well, A1 is your basic 3-wire fence. And we're saying that if you're going to have to take care of a fence, if somebody puts up a concrete fence or a brick and mortar fence, whatever the case is, and it's a much more expensive fence, the subdivision or the person that has that, the landowner on the other side of that shall only have to pay for half of the fence, but only if it was the reasonable cost of what the 3-wire fence would have been. So this is a much more appropriate way of saying you're not going to be responsible for 50% of the entire fence if they put up a white vinyl fence and you don't like that. This is bringing it back into line saying you only have to pay for 50% of this if it's within that 3-wire area. And then beyond that, the last portion that you see is on lines 34 and 35 where it says except for paragraph 3 of this subsection. The language that we had in there, as you keep reading, this was actually kind of a good catch by the Good Country lawyer, that we really kind of had superfluous language in here that really wasn't needed. And the way that this bill reads, it works well because we're striking subsection B. We're repealing that still. So there's really no reason to have any of the other exceptions. So with that, Mr. Chairman or Speaker Pro Tem, I'll stand for any questions.
Representative Crago for your first time.
Thank you, Mr. Speaker Pro Tem. So I just want to piggyback on that. This is a good amendment. I did work with the sponsor of the amendment. If we go back to and I just want to point out a couple things that were brought up during the discussion and just clear them up a little bit. The very first part of the amendment on lines 1, 2, and 3, there was a question brought up, well, what if the surrounding rancher, farmer, landowner doesn't want to put in a fence? So we put in an exclusion for that. So you can exempt out. If all the surrounding landowners say, we don't need a fence, we're fine, no fence is necessary, you just go get their consent, and that's what that First Amendment does. So that helps there. And then the other one was, well, what's this going to do to our counties? What kind of rules are we putting on them? How's it going to affect subdivisions, et cetera? And so that last amendment on lines 34 and 35, the way the bill is currently written, your county planning and zoning would have to institute this, would have to require, and there would be no way to exempt out of this, even if it was in your county, it's not necessary. What this does is say by rule or regulation, your county planning and zoning can say, we don't necessarily need this particular provision, but now that if we need to, we can always put it back into the rules, but it's taking that out so it's not mandatory on your counties. There are some counties where maybe this isn't a problem. There's lots where it is, and so we're going to give the counties a little bit of discretion back home to decide whether or not they need this or not. Thank you, Mr. Speaker Pro Tem.
Representative Alaman.
Thank you, Mr. Speaker. I know more than I wished I did about fences. Walked many miles of them. On our handout that we got, those are mountain sheep. And that 3-wire fence isn't going to hold them or hold any other sheep. And we're taking a problem that is not the ranchers and giving it to him. When the subdivider builds that subdivision, he usually has a surveyor come in. He usually has a home builder come in. He needs to also have a fence builder come in. And the problem should be his, because he's the one that's going to benefit from that fence. He's going to be able to sell his houses. The gentleman who has livestock around the subdivision, he didn't need that fence before the subdivision, and I don't really think he should need it after. It should be somebody else's problem and not his. Thank you.
Representative Bear for your first time.
Thank you, Mr. Chairman. I want to thank the good bringer of the amendment, and I'm on and for this amendment. Before it was corrected, I looked at this and I had a lot of concerns and went to the bringer of the amendment, and he was diligent to look at the statute with me and work through this. Fencing is not my expertise. They don't have a lot of fences on the ocean, and I won't go there, but this particular amendment addresses what the ranchers need, and I just heard the Good Country lawyer point out something that I hadn't thought about, and that is the fact that if a rancher does not need a fence, he's not responsible for a fence. I see the good bringer of the amendment shaking his head, but maybe you could get up and make sure of that when he has his opportunity. But this amendment is a good amendment because if I can explain it for just a moment, when a subdivision comes in and builds a fence to keep the cattle out of the subdivision, they can build whatever fence they want. But the rancher, if he's responsible for half of the cost of the fence, he's only responsible for that half of a minimal fence that's required for ranching. So his expense is appropriate for a ranching fence, which requires barbed wire and wooden posts at a certain distance, all the things that he would put up if he needed to keep his cattle contained. Whereas the subdivision does not need that other than to keep the cow chips out of their yards. So I would be on and for this amendment, and if the good bringer of the amendment can just confirm that, that one caveat that the good country lawyer brought up.
Representative Slagle.
Thank you, Mr. Speaker. Mr. Chair, I agree. I'm on and for this amendment. I think they've cleaned up a lot of the problems we had previously with the bill. And I think it just, especially the part where makes it so the rancher, landowner adjacent is only responsible for half the cost of maintaining just the required fence that's required by in our statutes right now. Thank you.
Representative Conrad.
Thank you, Mr. Chairman. The question that I haven't been able to resolve in my mind, and I apologize in advance, through reading this and also the amendment, which is very favorable, and I appreciate the time and effort that's taken to place that. My question comes from a constituent, specifically related to a county. Who enforces and what enforcement ability do they have in this regards? If there's a substandard fence or et cetera, so forth, if they identify it, whatever the case may be, who has the enforcement capability or capacity to ensure that this is correct as per the respective statutes?
Representative Smith for your first time.
Thank you, Mr. Speaker Pro Tem. I just have a couple questions as well, and I am in favor of the amendment. I'm just wondering how one would break down the cost to figure out what is an acceptable share price of the minimum type of fence. Is it wooden post? Is it T-post? Is it barbed wire? Is it without the barbs? And so, and then any scenarios where the subdivision owner wants a fancy Taj Mahal fence, but wouldn't necessarily keep cattle out, but the rancher decided to put up his own barbed wire fence to protect the white picket fence or something like that from his livestock ruining a fence and being responsible for it. What would be the outcome of that as well? So thank you for answering the questions.
Representative Banks for your first time.
Thank you, Mr. Speaker Pro Tem. I got a couple of questions. I want to just be sure that the liability thing stays in there, that that the rancher is not liable for that, because we want to make sure those protections stay the same. So my question is that piece staying in the bill? Because I think, and that adds to my next question, are we keeping the fence out provision of Wyoming? Does that remain intact with this amendment to this bill? Because I think that's vitally important to protect our ranches and stuff, that we keep that fence out provision. And then just from my own knowledge, so does the current statute read that the landowner is responsible for half of that fence? Because I thought the intention of this bill was to take the responsibility off the landowner or that rancher if a subdivision moves in and the landowner doesn't want to put a fence there. I thought the intention of the bill was to say, okay, it's going in, the subdivider has to put up the fence and he's responsible for it because that's his problem. So those are my questions, if they make sense. Thank you.
Anybody else for their first time? Representative Stivar for your first time.
First for a second.
Anybody else for their first time? For your second time, Representative Craigo, for your second time?
Thank you, Mr. Speaker Pro Tem. I'll try to answer some of these questions. There was a question about what if the subdivider builds a Taj Mahal type fence, but it doesn't hold livestock? Well, they can't do that under the bill or under the current statute. It has to be livestock tight, so to speak, and that's why we referred it back. Instead of listing 1128-106 within this bill, we just referenced back to 1128-106 and said the fence has to be built to one of these standards. And then there was a question about what happens on the cost, okay? So right now, as the law is currently written, and this is why we're bringing this particular piece of legislation, the rancher has to pay half of the cost of the fence, no matter what type of fence is built. And so what we're trying to clear up is the livestock owner, the rancher, should only have to pay half of a livestock type fence, not any other fence that would actually hold out livestock, i.e. we talked the other day about a 10-foot tall brick and mortar type fence. And so that's the purpose of that. The liability remains the same as it is under current law. We didn't change that with this amendment or with the bill. In the fence out, same thing. That's not going to change. There's some language in here about the liability that shifts to the subdivider. That's some language out of current statute that we just put into this bill. And essentially what it says is if you put up a lawful fence as the subdivider and my livestock tear down your fence, get into the subdivision and something happens to them, you're not liable. So I mean, it's what's good for the goose, good for the gander. It goes both ways on that. And so if you're doing your job and keeping the fence maintained as a subdivider, you shouldn't be liable for whatever damage those animals might cause once they get into the subdivision. And I think that's most of the questions.
Representative Allen for your second time.
Thank you, Mr. Chairman. First of all, under Wyoming law, you have to fence cattle out. And we're trying to change that now. You don't have to fence sheep out or horses out, but you don't fence cattle in, you fence them out. And I don't think why we should be changing Wyoming law that makes it harder on the guy who doesn't need the fence. Thank you.
Representative Conrad for your second time.
Thank you, Mr. Chairman. Question again, I apologize, I may have missed it and likely have. The enforcement component, who's responsible, who has the enforcement ability to ensure that the fence is correct, repays 0.5%, whatever it is? Thank you.
Anybody else for their second time? Representative Banks.
Thank you, Mr. Speaker. I appreciate the explanation, the answers to the questions by the good representative across the bighorns from me. And with those explanations, and the concerns being met, I understand the ability of needing to have some middle ground between our subdividers who are coming in and bringing some economic development to the state and our current landowners. I think this bill does that. And so I would urge and I vote going forward on this bill. Thank you.
Anybody else for their second time? To the sponsor, Chairman Brown.
Thank you, Mr. Speaker Pro Tem. So I just want to kind of cover, I believe, that the main question that I don't think the good country lawyer got was enforceability, and ultimately that comes down to the courts. And that is in statute right now in 1128, and I'm looking to make sure that I have it here. I believe it's 1128-103 is where the penalties and fines come in there, and that's where you'd actually have that adjudication coming through the court system. What I'll tell you is originally this bill, as it came over, I was not a huge fan. I thought, it took a lot of work to put this amendment together, to be honest with you. But one of the other questions I did hear, and I heard the concern about, is we're changing state law. It's exactly what we're doing, and that's what we do every single day. We change state law, and that's why we're changing this, is because we have a problem across the state right now when it comes to these particular subdivisions coming in, who's responsible for the fences and who's not. If they build a nicer fence than I'm willing to pay for, and the statute currently says I have to pay 50% of that, that's not fair to the landowner who doesn't want a white fence and doesn't want vinyl or doesn't want a concrete and stone fence. He just wants his simple 3-wire fence. So that's why we've amended this to say you are only responsible for the reasonable cost of a fence that is listed in 1128-102A1. And I want to read that just so everybody understands what that is. A fence made of steel, concrete, or sound wooden posts and 3 spans of barbed wire not more than 15 inches or less than 10 inches apart, or 2 spans of barbed wire with a wooden rail on top. Wooden posts shall be at least 4 inches, yada, yada, yada. So it's literally the cheapest portion of the fencing that's in here. And we're trying to say, hey, look, if you, the developer, want to build this monstrosity of a fence, fantastic, go ahead. But the landowner that you're coming into and you're butting up against only has to pay for 50% of a barbed wire fence. And that's all you're going to be responsible. That's all they're going to be responsible for. And also, I appreciate the good country lawyer bringing this up. If that landowner doesn't want a fence, he can exempt himself out. That was a huge issue to me yesterday. I totally spaced out when I introduced this amendment. We didn't have that, right? So this is an exemption opportunity for that landowner who says, I don't care if I've got people coming up here. I don't run cattle. I don't want to pay 50% of a fence. And then that subdivider says, well, I don't want to put up a fence. Hallelujah. We just solved the problem. So on and for this amendment, this was literally the best thing that I can probably come up with to make this bill as palatable as possible. I still don't think I like it a whole bunch, but I'm going to do my best to try to make it better. Thank you.
All those in favor of second reading amendment number 1 to Senate File 137, please say aye. Aye. Those opposed? Second reading amendment number 1 to Senate File 137 has been adopted. Representative Western.
Thank you, Mr. Chairman. I would like to withdraw second reading amendment. Second reading amendment 2 to Senate File 137.
Second reading amendment number 2 to Senate File 137 is withdrawn. Representative Sherwood.
Thank you, Mr. Speaker. I would like to read third reading amendment to Senate File 137. I would like to move it.
Please proceed.
Oh, thank you. Thank you. This amendment considers the need and practicality for wildlife-friendly fences. Now I have to find it. Sorry. Here we go. Okay, so if a subdivision in question is in an ungulate wildlife migration corridor, so an ungulate, for those who may not be aware, is a hoofed animal. We want to take in consideration best practices for both wire fencing, so that's defined in Section A, for buck and pole fencing, that's defined in Section B, and C for any other fencing that we can determine to be animal friendly. And the reason I'm excited to bring you this amendment is if you can imagine a pristine piece, of Wyoming land, your ideal ranch, and you're sitting at your kitchen table, having your favorite cup of coffee, and you look at out the window, right? You've spent all summer working fence lines, everything's perfect, and the herd of elk across the field gets spooked, and they just charge through that fence and obliterate it, right? So then, because the fence has not been constructed in a wildlife-friendly way, you as the property owner, whoever's responsible for the fence, has to spend more time and money, so your time is money, fixing that fence. So I see this amendment as both a way to be conservation-friendly, which is something we value in the state, but also to be economic-friendly and to be lower maintenance, meaning lower cost to maintain. Thank you.
Majority Floor Leader Nyman.
Thank you, Mr. Speaker Pro Tem. On and against the amendment, I've seen this personally. It does not matter if it's a smooth wire on top. It does not matter if there's a rail. It doesn't matter if there's a cable on top. If you spook a herd of ungulate animals and they leave a field in groups of any more than 2, they neglect to jump. They run straight through and they string wire. I've actually gathered up 1/4 of a mile of fence and put it back in. they're oblivious to what type of fence it is. They literally leave and they take it with them. So as far as, and many times these wildlife-friendly fences are far more costly because of the wire type, because of the different things that you need to do. Buck and rail, stuff like that, very expensive to put in. And so I would be on and against this amendment. They're going to go through it. If you spook them, you're going to be fixing fence. I don't care what kind it is.
Representative Banks for your first time.
Thank you, Mr. Speaker Pro Tem. Not trying not to repeat everything that was just said, but I agree. I'm on and against the amendment. If elk or even deer I've seen want to go through the fence, they're going to go through it. They're not going to stop and jump over because it's lower. It's going to blow right through it, and there's just nothing really we can do or fencing we can change to stop them from doing that. That's just something that landowners have grown up dealing with and are going to continue to have to deal with. This isn't going to change anything. It isn't going to add any protections to the wildlife. It's not going to help. So I would urge a no vote. Thanks.
Representative Bear for your first time.
Thank you, Mr. Speaker Pro Tem. I have to say, whoa, I think we're putting a glass slipper on this here fence thing here. This is something that whatever these wildlife are that come against it, they're going to shatter the thing. Not only that, we're restricting the ranchers and the people that own the subdivisions to a particular kind of fence in a particular situation. I really don't believe that's an appropriate thing to do in this situation. On and against the amendment.
Representative Newsom for your first time.
Thank you, Mr. Speaker Pro Tem. I just have a question of how do we know if it's a wildlife migration corridor? I know that we've had these discussions within this body in the past and have been reluctant to designate Wyoming migration corridors. And so, you know, we live a little bit south and west of town and we have deer and elk come through our place, but I don't know that we're a migration corridor or not. And I don't know how that would be designated. Thank you.
Representative Alaman for your first time.
Thank you, Mr. Chairman. Normally, we wouldn't be having this kind of problem in a subdivision because usually wildlife corridors don't go through subdivisions. So we really shouldn't have this problem. But we have built 80-foot gates so that we'd open them, hoping the elk could go through the gate. Where they tore the fence down last time, we put the 80-foot gate. They go down the fence about 50 yards and jump over and tear it down there too. Thank you.
Representative Ottman for your first time.
Thank you, Mr. Chairman. Out in our neck of the woods, I don't know if you would call it wildlife corridors, but we're having a lot of wild horses and buffalo, and they are free to roam. Years ago, living up in Washington, a friend asked somebody to take care of her buffalo while she was gone. Well, by the time she got home, the fences were destroyed. The buffalo had been up to the house. You cannot fence in a buffalo. You distract a buffalo. So to try and do this, it's not possible. It's not a perfect world, and you're not going to stop them. So thank you.
We are on second reading amendment number 3 to Senate File 137. Anyone else for their first time? Anyone for their second time? To the sponsor, Representative Sherwood.
Thank you, Mr. Speaker. So great questions, great dialogue. I appreciate that very much. So a wildlife corridor does have a designation process. This is established in our an executive order in February of 2020, Executive Order 2020-01. So there is a very formal process that happens that is based on science and data, extensive public engagement. The agency that manages our wildlife is involved, but at the end of the day, our chief executive has a working group and sort of final say on whether or not there is an official designation. So if the idea of not having to fix fence as much doesn't persuade you, I would say
Wildlife is our shared resource. Wildlife-friendly fences reduce injury and death to that very special asset that we all hold dear. Thank you.
All those in favor of second reading amendment number 3 to Senate File 137, please say aye. Those opposed? No. Second reading amendment number 3 to Senate File 137 has failed. Senate File 137, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 140.
Senate File 140, sponsored by Senator Pappas. Building code requirements, refrigerants.
Senate File 140, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 154.
Senate File 154, sponsored by Senator Cooper. Energy Authority Project Financing Refineries, an act relating to the Wyoming Energy Authority.
Senate File 154, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 157.
Senate File 157, sponsored by Senator Cooper. Weed and Pest Mitigation, Tribal Inclusion 2, an act relating to weed and pest control.
Senate File 157, having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate File 169.
Senate File 169, sponsored by Senator Hicks. State Shooting Complex Task Force, an act relating to the administration of government.
We have an amendment. Representative Yan.
Mr. Speaker Pro Temp, I move second reading amendment number 1 to Senate File 169 and ask for your favorable consideration. So members, I was thinking about, because we get members from the legislature appointed to the task force, what I don't want is that those members decide that their own community is the one that gets the recommendation. So this way, with this amendment in place, we ensure folks that who are not looking to put the shooting complex in their own community, they're the unbiased ones that can choose a different community to put those shooting complexes on. Because at the end of the day, if they end up choosing their own community, we all know that we're going to debate whether that community is the appropriate one. So this is one little sideboard in making sure that the recommendation goes to somewhere representative in the body that isn't biased by the members who are appointed to the task force. So I ask for your favorable consideration. Thank you, Mr. Speaker Pro Tem.
Representative Larson, JT, for your first time.
Thank you, Mr. Speaker Pro Tem. I am on and against this amendment. The goal of the task force is to come up with the best location for this facility. And it's not just going to be one person who makes the decision on where it's going to go. It's going to be a group of us, likely legislators from different parts of the state. So I don't think that we're going to run into that issue of getting it in one specific county or city.
Chairman Washut, for your first time.
Thank you, Mr. Speaker Pro Tem. Just to remind the body that this task force will consist of 12 members. So the preference of one legislator among those 12 task force participants is not going to carry the day. In addition, there are going to be 4 legislators. In all likelihood, they're going to come from 4 different communities. Do you really want to eliminate all 4 of those possible locations from any consideration? If the communities put together a great proposal and it's, amazingly good proposal, but we're just automatically excluded from considering that community's request because they had the misfortune of having one of their legislators on this task force, doesn't seem like good policy making to me. So please vote no on the amendment.
Representative Hornock, for your first time.
Thank you, Mr. Speaker Pro Tem. If this amendment does pass, I'd like to volunteer not to be on the task force.
Representative Bear, for your first time.
Thank you, Mr. Speaker Pro Tem. I want to voice agreement with the good representative from District 17, as well as the good chairman of Judiciary. We are really, with this amendment, restricting all of the good possibilities, and we would want to pick the best possibility for something like this. This is going to be an attraction for the entire state to be proud of, something that people will come from all over the country, all over the world to visit our state for. And this committee should be tasked with finding the absolute best possible location for the entire state's sake. And having said that, if we put this restriction on it, we've just eliminated, as the good chairman of Judiciary said, 4 locations, or at least 4 regions. And I don't think we want to do that unless we want to pick those legislators based on how bad the locations are that they might provide. And I don't think that's the direction we want to go in this situation. We might have some volunteers for that. But really, we should not be this restrictive. We have a great opportunity here. Again, I was against this bill in the beginning. You got me on board now, so let's make sure that we do this right. Thank you, and on and against the amendment.
Representative Banks for your first time.
Thank you, Mr. Speaker Pro Tem. So we're here to represent our area, and that trickles down into committees as well as these task force. So if we take away the ability to do that, we're taking away our elected duties to represent our area to the best of our ability. And I'd be remiss if I didn't say that I'm going to push to be on the committee and going to push to get this complex up in the Bighorn Basin. And having that taken away from me, there's not very many of us here that represent that prime area of the state. And so taking that away would really hurt not only our area, but the ability to bring that to that gray area of the state. So taking away these locations right off the bat, I don't think is going to be a benefit to what this legislation is intended to bring to the state. So on and against the amendment.
Representative Berger for your first time.
Thank you, Mr. Speaker Pro Tem. Appreciate it. And kind of add to what the good representative said from the Bighorn Basin. I don't want to take away from anybody getting this, and I'm against this amendment, and I don't want to see it through, but I'm ready to arm wrestle for it. I'm ready to go. And maybe we need to add an amendment, or add, if we do this, add arm wrestling, and let's see, pick a winner.
Representative Alaman for your first time.
Thank you, Mr. Chairman. If this complex had come to the home of many oil wells, I'd gladly not be on the committee, but I know it's not. But it's not right to stop a representative from representing his town. Thank you.
Anyone else for their first time?
Point of order, Mr. Speaker. Mr.
What's
Chairman?
your point?
I don't think this is germane, or I think it's a constitutional issue, excluding these districts. And I would like to call a Rules Committee.
Okay, we'll have the Rules Committee come to the front. Representative Bear. Representative Bear, would you like to withdraw your point of order?
Thank you, Mr. Speaker Pro Tem. I withdraw my point of order at this time.
Okay, House come to order. Anyone else for their first time? We're addressing second reading amendment number 1 to Senate File 169. Anyone else for their first time? Anyone for their second time? To the sponsor, Representative Yen.
Thank you, Mr. Speaker Pro Temp. So all that I will say is that, I mean, I think the intent here, and you've heard from many members who are interested in also being on the committee and then recommending their own community, that's what I would like to avoid, because that ends up coming to the floor with all the people who did not get on the task force arguing that that community ended up being the wrong choice. Vote aye, vote no, but I think that is something that we should worry about on the task force. Thank you, Mr. Speaker Pro Tem.
Okay, all those in favor of second reading amendment number 1 to Senate File 169, please say aye. Those opposed? No. Second reading amendment number 1 to Senate File 169 has failed. Senate File 169 having been read 2 separate times, the question is, shall the bill be read a third time? Hearing no objection, it is so ordered. The next bill for our consideration is Senate Joint Resolution 3. We have an amendment.
Senate Joint Resolution 3, sponsored by Senator Doc Stater. Property tax exemption for the elderly and infirm. A joint resolution to amend the Wyoming Constitution by authorizing a homeowner's property tax exemption for the elderly and infirm.
I believe we have an amendment. Representative Locke. Representative Locke.
Thank you, Mr. Speaker. I just wanted to bring this issue up because it came up yesterday in conversation, and it was a question. I'm sorry, I need to move the amendment. My bad. I want to I move second amendment number 1 for Senate Joint Resolution 3. I just wanted to bring this particular issue up for discussion more than anything, just to make sure we had an opportunity to bring this up, because I think at the end of the conversation yesterday, there was some discussion whether it should be and or. And I wanted to at least bring that conversation up. I know there was several people, a handful of people who mentioned that, and I wanted to just bring this up. I'm not legally knowledgeable enough to know, but I wanted to bring that issue up to identify it. Is it a real issue? Is it not an issue? So this is more of me honestly asking a question, is all this amendment really is. So this was my attempt to get someone to explain, or at least bring up and say the and is correct, or it should be or. Thank you.
Representative Pendergraft for your first time.
Thank you, Mr. Speaker. On and for the amendment simply because it broadens the base of people that are covered under this tax exemption. I would be against the actual bill itself because I believe it's discriminatory. I think it is imperative that we tax as evenly as possible and as fairly as possible. And you can take any segment of society and divide it up and find underprivileged among them and people who are hurt by that. I'm very sympathetic to the plight that we're trying to work here, but there are plights in other segments of society as well. And I would prefer an even and fair tax break.
Representative Chestick for your first time.
Thank you, Mr. Speaker. And thank you to the bringer of the amendment for providing an opportunity to clarify this. There is no right or wrong answer here. If you want both conditions, you put and. If you want either one, put or. And that's not a legal choice. That's a policy choice. So what policy do you want? That's up to this body. But I do appreciate the opportunity to have this discussion. Thank you.
Representative Clouston for your first time.
Thank you, Speaker Pro Tem. My question to the body is, what is our definition of infirmed? Who's going to qualify for that? Do you have to be on disability? I mean, it's a weakness of mind or body, feebleness. There's a lot of people that could qualify for that, so I think we need to be a little bit more defined. Thank you.
Chairman Brown for your first time.
Thank you, Mr. Speaker Pro Tem. To piggyback off of the question there, and I actually just went and pulled, definition of infirm, just so I actually had a strict definition of it. Not physically or mentally strong, especially through age or illness. And so I think the policy decision then becomes, okay, do we want to tie the infirmity to the age portion and the elderly, or do we want to say anybody who's not physically or mentally strong? And then that kind of gets left up to a bureaucratic decision-making of what does that actually mean? And we tried to define elderly yesterday. We did an okay job, I suppose. But it really just brings into the question a little bit more of when you strike out that and/or, and you put that in there, it becomes a much broader scope than I think the original intent was. And, the bill calls itself for the elderly and infirm, not the elderly or infirm. So it's a choice that we all get to make, but I don't think I am going to be in favor of expanding this out. I think the idea was to give it to those who are older and not able to care for themselves. So thank you.
Representative Bear for your first time.
Thank you, Mr. Speaker Pro Tem. I am kind of curious as well, numerically, and we don't have a fiscal note really that'll tell us what would happen here on a joint resolution like this, as this will go to the voters. But when we include a larger group, which this would do, I generally prefer that. I'm not sure that I do here because I'm not sure that the infirm, as they're defined, are actually going to be property owners. Remember, this is about a property tax refund. So we need to keep it on the people who are actually paying the tax. So with this definition, as we've heard today, being so broad, I'm not sure that we're actually targeting people that are paying taxes. Something that until today, we really haven't gotten a bill before us that will do that. Today we did, and hopefully this body will get to debate that next. But I am at this moment on and against the amendment simply because I don't think it's broad enough for taxpayers, and yet we don't have a good definition of what infirm is as far as all the other things that.
Representative Penn for your first time.
Thank you, Mr. Speaker Pro Tem. So I would be on and for this amendment as, I'm always wanting to broaden what tax relief we can offer to people. I do think that, as two speakers ago, it broadens it significantly because the definition of infirm is very broad. And so I would be in favor of this if this is what the body chooses, where the body chooses to go with this amendment. Thank you.
Representative Alaman for your first time.
Thank you, Mr. Chairman. I'm on and for this amendment, and I'm on and for the bill. We are going to see a little bill come out of committee today, but that's only $17 a month to help these people out with taxes. The elderly, if you're 75 years old, you're on a very small income. And I know it's picking and choosing, which we shouldn't be doing, but I'm willing for some property tax for the people of House District 58. They need help, and I'm willing to give it to them. Thank you.
Representative Davis for your first time.
Thank you, Mr. Speaker Pro Tem. I too have the question about the infirm. Are the infirm currently paying property taxes? Is there a number out there that we can identify?
Anyone else for their first time? Anyone for their second time? To the sponsor, Representative Locke.
Thank you, Mr. Speaker, and thank you for the conversation. To be honest with you, I honestly just brought it up for the conversation so I could understand better what it was all about. I'm going to say what I never say, which is vote your conscience. I don't know what the right approach to this is, but thank you.
All those in favor of second reading amendment number 1 to Senate Joint Resolution number 3, please say aye. Those opposed? Senate Joint Resolution, second reading amendment number 1 to Senate Joint Resolution number 3 has failed. Representative Haroldson.
Thank you, Mr. Chairman. At this point in time, I bring second reading amendment number 2 to Senate Joint number 3, and I ask for I move. Did I say I bring? I move amendment number 2 to Senate Joint number 3 and ask for your favorable consideration. So yesterday we had a conversation of 75 and 40 years, 65 and 20 years, what's elderly. I just thought I'd take another whack at this and bring in something that is adjusted by our federal government as to what actually is considered at a retirement age or an age when we see more of a fixed income. So this is for fixed income. That's where this is a need. So obviously when you're in the working force, if things get a little tight, you add a little extra pay in with some overtime or with whatever. But when you're in retirement mode and a fixed income is there, that's where this is really going to be needed. So this amendment just simply states that for the purpose of this selection, elderly means a person who is eligible for Social Security benefits and who has been a resident of Wyoming for at least 30 years. So I think it's a good way of defining it and would ask for your favorable consideration.
Representative Provenza for your first time.
Thank you, Mr. Speaker Pro Tem. I have a question for the bringer of the amendment. So for folks to be on Social Security, I mean, most folks over this age can qualify for it. However, there are people who maybe haven't worked enough terms or quarters or something that can't qualify. For example, my mother doesn't qualify for Social Security at this point because she was a stay-at-home mom. She was disabled and didn't pay enough in. And so I'm wondering, for the people who maybe don't qualify for Social Security, not because of age, what happens for those folks? Thank you.
Anyone else for their first time? Representative Berger.
Thank you, Mr. Speaker Pro Tem. At one time, they used to say 50 was old. And I'm almost there, and you'd get a senior discount at Sizzler. Now, we're trying to change all these different ages, and as much as I like this bill, I think we have a lot of people still even under 65 or whatever that need help. That's why I'm saying, as much as I like this bill, I really like, I wish we could bring all these tax relief bills together and make one giant awesome tax relief bill. That's what I want. I'm still kind of deciding.
As a reminder, we don't use individual names. For your first time, Representative Newsom.
Thank you, Mr. Chairman. So generally, you're eligible for Social Security at age 62. And so at that point, and there's also other Social Security benefits that are available to young people, depending on their life circumstance. So I don't know that using Social Security benefits as a qualifier are the wisest choice. Thank you, Mr. Speaker Pro Tem.
Representative Lawley for your first time.
Thank you, Mr. Speaker Pro Tem. I appreciate the bringer of this amendment because it addresses a concern I have about the bill, but I'm not sure it hits the mark. That the bill refers to meet the constitutional tests as needed for support of the poor, but there's nothing in the bill that requires any financial requirement or need be proven. So it seems like an empty phrase in the bill. So this does address that. But I'll say, as someone who is on Social Security, that I think we might want to look at, and if you know when you say ineligible for Social Security, I'm not sure what you mean. And if you're talking about some kind of income threshold, because I'm not sure that is correct. So again, I have a question for the bringer of the amendment and appreciate the idea behind it.
Chairman Washut for your first time.
Thank you, Mr. Pro Tem, Speaker Pro Tem. Just so the body's aware, we have a number of civil service employees in Wyoming who do not contribute to Social Security. And if they work a sufficient number of years in that civil service position, they're not going to qualify for Social Security benefits. And therefore, I think this is a problematic definition. In addition, what this joint resolution provides for us is if the voters agree, it comes back to us as the legislature to fill in the details. And the Constitution constrains us to work for the benefit of the poor. We then will deal with that definition at that point. So I don't know that we need to fill in all the blanks now on the joint resolution. We'll do that when the people, if they choose, send it back to us for further action.
Representative Conrad for your first time.
Mr. Speaker, thank you. Question to our good friends in appropriations. If this amendment were successful or I guess to the good bringer, how much money would this cost the state? How many millions would this cost if we reduced it to the age of, say, 62? What is the financial impact to the state? Thank you.
Chairman Burkhart for your first time.
Thank you, Mr. Chairman. Just a reminder, most firefighters and railroad workers don't catch Social Security at all.
Representative Zwanitzer Dan for your first time.
Thanks. And to answer that question from a couple of speakers ago, so this is still permissive language. So until the legislature further acts, it wouldn't actually have a fiscal impact. I do think it's kind of weird to put a federal program in the Wyoming State Constitution. We haven't tried that one before. And what if it does go bankrupt like some people are saying it will? I'm not sure, but I think it's a pretty bad idea to put this language in the Wyoming State Constitution, and for that, I'd ask you to vote no.
Representative Hornock for your first time.
Thank you, Mr. Speaker. Another group of individuals who can choose to opt in or opt out are the clergy. So we may be excluding some of those, and the good bringer of this amendment may or may not fall into that category as well. So, so clergy can exempt themselves from Social Security if they so choose. They can opt out.
Representative Penn for your first time.
Thank you, Mr. Chairman. So I appreciate the comment a couple speakers ago about remembering that this is a constitutional change and therefore this language would go into the Constitution. I think that's important to think about. I do appreciate that this amendment lowers the requirement of residency from 40 years that was previously adopted now to 30 years. For the constituents that I'm thinking of at home who have personally contacted me on this issue, this still isn't enough. It still wouldn't cover them. And so I still have that concern that it's a little too restrictive. Thank you.
Anyone else for their first time? Anyone for their second time? To the sponsor, Representative Haraldson.
Thank you, Mr. Chairman. So 62 is the Social Security age. So that was what I was going for. But if Social Security age were to change, this would shift with it. I'm throwing an idea out there, just having the conversation. If do we really want 75-40? Do we want something different? Is this the fit? I don't know. I mean, a good point is this is going in the Constitution. Do we really want that in the Constitution, or do we want this in the rules we make later? So definitely, it's another option. If we want to go 62 and 30, it would open the window a little bit more. It would protect a little bit more, and we could definitely try to, when people are going into that fixed income bracketry, try to help offset and try to help fix. And so for that, I believe it's a good option to help and to just further try to kind of open this to those that really need it. So I ask for your favorable consideration.
All those in favor of second reading amendment number 2 to Senate Joint Resolution number 3, please say aye. Those opposed? No. Second reading amendment number 2 to Senate Joint Resolution number 3 has failed. Senate Joint Resolution number 3, having been read 2 separate times, the question is, shall the bill be read a 3rd time? Hearing no objection, it is so ordered.
We're going to go a little bit out of order here so we can get our third reading done. We are at that order of business of bills on third reading and final passage. Mr. Majority Floor Leader.
Mr. Speaker, I move third reading consent list consisting of the following Senate files. Senate File 75, Senate File 123, Senate File 129, and Senate File 148.
Would anybody like to remove any of those bills on the consent list? Having been read 3 separate times, the question is, shall these bills pass the House? Let me see, the reading clerk will read the bills on the consent list.
Senate File 75, sponsored by Blockchain, Decentralized Autonomous Organizations Amendments, an act relating to corporations being enacted by the legislature of the state of Wyoming. Senate File 123, sponsored by Senator Boner, Military Dependents, School Choice, an act relating to education being enacted by the legislature of the state of Wyoming. Senate File 129, sponsored by Senator Landon, Background Checks, Governor's Office, an act relating to criminal history records being enacted by the legislature of the state of Wyoming. Senate File 148, sponsored by Senator Kinski, preemption of local firearms regulation, an act relating to weapons being enacted by the legislature of the state of Wyoming.
Having been read 3 separate times, the question is, shall these bills pass the House? The chief clerk will please call the roll.
Ellerman, Allred, Andrew, Angelos, Banks, Bear, Berger, Brown, Burkhart, Byron, Chadwick, Chestick, Clauston, Conrad, Crago, Davis, Eklund, Harrelson, Harshman, Heiner, Hornock, Henderson, Jennings, Knapp, Larson Lloyd, Larson JT, Lawley, Locke, Nyman, Newsom, Nicholas, Nemec, Northrup, Oakley, Obermuller, O'Hearn, Olson, Ottman, Pendergraft, Penn, Provenza, Rodriguez-Williams, Sherwood, Singh, Slagle, Smith, Stith, Storer, Strock, Stivar, Tarver, Trujillo, Walters, Ward, Washut, Western, Winter, Wiley, Yin, Zwanitzer Dan, Zwanitzer Dave, Speaker Summers. Are there any changes? Closing vote. Vote closed. 61 aye, 1 excused. As for Senate File 75, are there any changes? Are there any changes? Winter? Aye to no. Further changes? Closing vote. Vote closed. 60 aye, 1 no, 1 excused. As for Senate File 123, are there any changes? Are there any changes? Closing vote. Vote closed. 61 aye, 1 excused. As for Senate File 129, are there any changes? Jennings? Aye. To no? Further changes? Closing vote? Vote closed. 60 aye, 1 no, 1 excused. As for Senate File 148, are there any changes? Are there any changes? Chestick? Aye to no. Further changes? Closing vote? Vote closed. 60 aye, 1 no, 1 excused.
Having received the affirmative vote of the majorities of the members elected to the House, Senate Files number 75, 123, 129, and 148 have passed the House. We are now at that order of bills on third reading regular list and final passage. The first bill for our consideration is Senate File 97.
Senate File 97, sponsored by Senator Hicks, Education Trust Fund Transfer, an act relating to the Wyoming Education Trust Fund being enacted by the legislature of the state of Wyoming.
We have amendments. Chairman Nicholas.
Thank you, Mr. Speaker. I would move third reading number 1 just to Senate File 97 and ask for your aye vote. Ladies and gentlemen, this is the action of your Appropriations Committee. We reduced the amount of funding requested by $250,000. After just reviewing the bill and the cost, we thought this was a more appropriate number.
All those, Representative Bear?
Thank you, Mr. Speaker. I just would like the bringer of the amendment to explain where this money is going exactly and why a reduction in half is appropriate. I just don't understand what the flow of this money is.
Anybody else for their first time? Representative Stiff for your first time.
Mr. Speaker, so these grants were from the interest from the Education Trust Fund, and they were used for so-called innovation grants by school districts that are competitively bid by the school districts to our department that deals with education. And the money is used then for career and technical education programs. So for example, purchasing 3D printers, having other things that a school district or school may want for its career and technical education program.
Anybody else for their first time? Anybody for their second time before the sponsor? Question being called. All those in favor of third reading amendment number 1 to Senate File 97 signify by saying aye. Aye. All those opposed? Third reading amendment number 1 to Senate File 97 has been adopted. We are now on third reading amendment number 2 to Senate File 97. Representative Davis.
Thank you, Mr. Speaker. I'd like to move third reading amendment number 2 to Senate File 97 and ask for your favorable consideration on this. What I would like to do is bring us back down to what the intent of the bill is. And that was to bring it back bring the small cans of funds out there and bring them into one large can and improve our interest from it. And what I see here is by diverting the $250,000 back out for the innovative program grants, it seems to me like we're skirting the intent of this bill by doing that. And what I have found out over the last few years is that there are 4 to 5 larger districts that do usually qualify for these funds. But that leaves the remainder of the state, the smaller districts, have not been able to qualify for these funds. So I would believe that in order to keep a level playing field for all of the school districts across the state, that this should go back to the corpus and we should get higher interest rate as what's been presented time and time again here. So I would be looking for a favorable on this amendment.
Representative Walters for your first time.
Thank you, Mr. Speaker. On and against the amendment, there might be a little misunderstanding as to what this bill does, even with the amendment. This bill does move all of that funding from the Education Trust Fund to the Common School Permanent Fund. So it will generate more interest. That's what we want, spot on. That's what this bill does. What the amendment does is simply leave the program in place. So then funds, because the money, the $5 million has gone into the corpus, so it's going to generate more interest. That interest will then flow to the Common School, the SFP, the School Foundation Program account, and then $250,000 from the School Foundation Program account will be held aside for every district in this state to apply for these funds. Every district is already eligible to apply for these funds if they so choose. It is already an even playing field. The amendment simply leaves the program in place. The bill moves the $5 million to the permanent corpus, gets us more interest. The $250,000 is $250,000 is what it was generating in the SAP. So it will that $5 million will actually generate more in the corpus than it was generating today, and more than it will be expending when now that we have lowered that to $250,000. So again, on and against the amendment, all the amendment that is here is the amendment that's brought, I don't think is brought with the full understanding of what the bill does. The bill, as the standing committee amendment does, with the bill, moves it, as I said, to the corpus, keeps the program in place. All districts are already on an even playing field. Again, on and against this amendment for the bill, it does great work with our money.
Representative Bear for your first time.
Thank you, Mr. Speaker. I appreciate the bringer of the amendment, and I've got questions now for the Appropriations Committee now that I've heard this. So there's 4 districts that are able to use this program, and basically the change that this bill originally was going to do is, it sounds like it's going to eliminate this program. So is this program a viable program? What is it that makes the appropriators want to maintain the program and its funding? And as a comment to overall our funding of education, I think that this addresses, the bill itself addresses simplifying how we fund our schools so that we can better tell what is the real cost of education. That is something that I'm a proponent of, and I do believe the bill as unamended does that. So does this amendment change that? The gist of the bill, is the bill completely eliminating the program, and what does that program, what is the utility of that program, or what is the use of the program by the districts statewide?
Representative Hornock for your first time.
Thank you, Mr. Speaker. Along the same lines, if we do have a program and we're adding funds to it with this amendment, the amendment might take that away. I'd like to know how much is in the program, how vital is it, how much money has been spent within those programs. The amendment earlier just kind of deleted a section that says if there's money, then they can be used. How much money are we talking about? That's what I would like to know.
Representative Larson Lloyd.
So if we maybe can go back and look at the bill's intent as we received it, which was to repeal the Education Trust Fund and put those funds in the permanent account, which this bill does. Nothing, none of the amendments or anything that we've done changes that. When we done that, when we looked at it in appropriations, the question that come to us was, what are we using? What is this innovation? What are these innovation grants? We weren't quite sure. And we wanted to make sure before we done away with that, that we understood who and what they done. And was, as was pointed out by my good colleague from the center part of the state, that it goes out for CTE innovation funds on how to teach these career technical development programs, and are available to any school district in the state. They're not restricted, but largely there's been 4 districts that have used them. But that's at no fault of their own. They're applying and receiving them. So what we do, what the chairman's good amendment does, is it doesn't do anything to that corpus that we now get rid of, this coffee can that we've dug up and threw in the wheelbarrow. It's gone. The money is all where everything else is at. But we allowed the Department of Education to use $250,000, I think that's where we're at now with this last amendment, to the Department of Education from the interest generated in that permanent fund for CTE grants to the school districts, as the departments indicated that those have been used well, and thought that the program was worth continuing as we try to focus on CTE type of education. So to delete, so I would just encourage you to vote against this amendment, because I think it does away with the ability to the program and doesn't impact the intent of the bill as it came over to us.
Representative Sherwood for your first time.
Thank you, Mr. Chairman, and thank you again for the questions. I think anytime that we can provide more transparency or correct information on an issue, it's beneficial for this body and for the general public at home. So this program is found in statute, Wyoming Statute 21-22-106. And so you can go to that statute and read through the intent. And there was money, about $500,000 allocated to this, with the idea that interest earned off of that would go to generate these grants. So again, what this bill is doing is putting that money into an account that earns more interest. But what it inadvertently did was delete this program. So that's what the amendment coming out of your appropriators was, to maintain the program. And I want to correct my good colleagues in saying, not only is this available statewide, I will send out a link where you can read through their grant reports. And even in 2 clicks through grant reports, I'm hitting more than 4 counties. So I'm not sure where that information came from, that only 4 counties were using it. That is incorrect. And I will send out clarification on that so you can see how your community has used this fund to enhance innovation in our classrooms. Thank you.
Representative Stiff for your first time.
Yeah, just briefly, on and against the amendment. As everyone knows, this amendment would eliminate the program entirely, and this is a competitive, innovative grant. So there's really no reason for career and technical education that I think all of us broadly want to support. So there's really no reason to eliminate the entire program. We've already achieved our goal in the bill of getting the higher investment return. So on and against.
Anybody else for their first time? Representative Alaman for your first time.
Thank you, Mr. Speaker. I'm having trouble understanding exactly what we're doing here. Did we put this money in during the budget and now we're taking it back out? And I just don't know why we're taking it out or where it's going, or I'd just like to know some of those things. Thank you.
Anybody else for their first time? Representative Obermueller.
Thank you, Mr. Speaker. I think I can answer that in terms of where it's coming from. If you go to your data book, page 142, it's about the third item down is what we're actually talking about. So 4,995,338. Thank you, Mr. Speaker.
Chairman Brown for your first time.
Thank you, Mr. Speaker. To the good representative from the center part of the state that was asking exactly what we're doing,
just kind of take us back 2 or 3 steps. This bill was brought to us by one of our colleagues down the hall, and there was an account, or if you will, what is commonly referred to in this body as a coffee can. About 20 years ago, there was a surplus of money, and they dropped $5 million into this quote-unquote coffee can. And in that coffee can, a couple years subsequently, they decided, hey, this is earning a little bit of interest. We're going to create a program that is for these innovation programs, and that's going to fund some innovation throughout the state for these school districts to go after. So for the past 20 years or so, this has been funding those programs out of this $5 million that was put into a tiny little coffee can. This bill came through, and as it passed the other body and into our body, eliminated the program and took the $5 million and put it straight into the corpus of the common school land account, okay, or permanent fund. And what that ultimately was trying to do was just bolster that, say, we don't need this $5 million earning this little amount of money, put it in towards the larger amount of money, let's earn some money and stop the program. Our appropriations team saw, no, there's benefit in this program, but we actually do agree we should probably be earning more interest off this. So let's take that $5 million, throw it into the bigger account, and let's make some more interest off of that. But we also think that the $500,000 that we were doing in grants is probably a bit too much. So the last amendment that you just voted on put that at $250,000 in grants in a year. So that's where we're at. That's what you're voting on. And that's in essence what the division or what this policy decision is that you're getting ready to make is the good representative from the Little Snake has said, take all those amendments that the standing committee brought forward and just eliminate the program and drop the money back into the account? Or do we want to keep this program up and running with $250,000 for these school districts to apply for these innovation grants? So that's what you're looking at. Thanks.
Anybody else for their first time? Representative Ottman for your first time.
Thank you, Mr. Speaker. And not to belabor the point, but just point of clarification again from the good representative. What I thought I heard was that we're putting, by the amendment that we brought, we are putting it back to the original intent, but the amendment changed the bill. So this amendment puts it back because it eliminates the previous amendment. So if you could just please clarify that. Thank you.
Representative Banks for your first time.
Thank you, Mr. Speaker. Quick question. So if we enact this amendment and take away the program, are the school districts still able to apply for funds through their CTE program with money directly from the corpus? That's my question.
Anybody else for their first time? Anybody for their second time before the sponsor? Representative Walters? For your second time.
Thank you, Mr. Speaker. To try and answer a few of these questions. So if this amendment were to pass, the entirety of the program goes away. That answers that question, which means that these districts can no longer apply for these funds. If this amendment does not pass, then we will have $250,000 available for the program that has been in existence since the early 90s. And it has been used every year by every district in the state since the early 90s. Now in the statute, in this very 21-22-107, it sets out to go against this misconception that there's 4 big districts always getting this. You're only allowed to apply for this once every 5 years. Furthermore, it delineates that a district less than 500 will be one classification, ADM. A district between 500 and 1,000 will be a different ADM, between 1,000 and 2,000 and over 2,000. And each one of those categories will be evaluated separately and available for funding. So what that does is make sure that our small districts get these funds, our larger districts, our mid-sized districts. That's in statute. That's the program we're talking about eliminating right here with this amendment. That's why I would encourage a no vote on this amendment and a yes on the bill, as the standing committee amendments have kept the program in place and moved the funding to the corpus so we generate more money. So no on this amendment, yes on the bill. Thank you for your time.
Representative Hornock for your second time.
Thank you, Mr. Speaker. And I appreciate the debate because it does add a lot of clarity to what we're discussing here. And I just wanted to kind of read through the statute to let everybody know what these innovation program grants go to. And I would argue that as I read these, I want you to think about whether or not we kind of already do this. If $250,000, which is kind of a drop in the bucket, would enhance any of these things that we may already do. Curriculum development activities, such as initiatives in world languages, mathematics, social studies, English, sciences, that kind of thing. Operational initiatives such as modifications to class schedules, school days, weeks, months, years, calendars, and scheduling of extracurricular activities. Administrator and staff development and improvement programs such as performance initiatives, awards for excellence. We're buying awards with this. Professional training and development programs and performance evaluation programs. Number 4, acquisition of technology equipment for programs expanding curriculum, enriching students' education, enhancing staff development, and providing community service. Number 5, applied science and technology programs designed to meet future labor market demands and to integrate public school programs with the needs of businesses and industries. I think we actually talked about a bill earlier that would really fit that category that we're going to do. Technological preparation programs integrating specific public school programs with the community college programs and working with businesses and industries to prepare students for technical and academic careers. Evaluation programs designed to determine the effect and achievement of the innovative programs, so we can fund a program to see if the innovative program is actually working or not. Regional development programs, including those designed to better prepare children for elementary school and to improve parents' skills in developing their children's learning skills. So I would just argue $250,000 seems like a minuscule amount. I think that we've kind of got those things covered generally in the entirety of what our education system does. Thank you. Vote aye on the amendment. Thanks.
Anybody else for their second time? Representative Alaman for your second time.
Thank you, Mr. Chairman. I'm still trying to get this figured out. The good bringer of the bill from Natrona County said if we vote aye on this bill, it will kill the program. Well, when the program was initially brought in, there wasn't, both of these amendments were not on it. So I'd just like to try and understand that a little, because both of these amendments, if they're gone, it'll put it back to the original bill. And I'm sure they didn't want to kill it then. Thank you.
Anybody else for your second time? Representative Davis.
Thank you, Mr. Speaker. Maybe I can try and address some of it to the way I understand this going forth here. But what we're trying to do is gather up all the coffee cans and put them in a higher interest rate, right? Okay. But somehow in there, we are taking $225,000 off of, I'm not sure where that funding's coming from, but that will become an ongoing expense if I'm not following this correctly, whether it's funded off of this or out of that over there. Okay, so that part I am following. So as far as the disclaimer about the program going away, I would imagine that would be up to the other fund these $250,000 would be coming out of, if that makes sense. And then as far as being available to the smaller school districts, you know, a lot of times our small school districts don't have the personnel available to write for these grants. So I think there is a little bit of a unlevel playing field there. And with that, I believe that I would like an aye vote on this. Thank you.
All those, we're done. I went to the last guy, the guy that brought the amendment. All those in favor of third reading amendment number 2 on Senate File 97 signify by saying aye. All those opposed? No. Third reading amendment number 2 to Senate File 97 has failed. Senate File 97 having been read 3 separate times, the question is, excuse me, shall the bill pass? Chief Clerk, please call the roll.
Elleman. Allred. Andrew. Angelos. Banks. Bear. Berger. Brown. Burkhart. Byron. Excused. Chadwick. Chestick. Klauston. Conrad. Crago. Davis. Eklund. Haroldson. Marshman. Heiner. Henderson. Hornock. Jennings. Knapp. Larson Lloyd. Larson JT. Lawley. Locke. Nyman. Newsom. Nicholas. Nemec. Northrup. Oakley. Obermueller. O'Hearn. Olson. Ottman. Pendergraft. Pendergraft. Penn. Provenza. Rodriguez Williams. Sherwood. Singh. Slagle. Smith. Stith. Storer. Strock. Stivar. Tarver. Trujillo. Walters. Ward. Washut. Western. Western. Winter. Wiley. Yin. Zwanitzer Dan. Zwanitzer Dave. Speaker Summers. Are there any changes? Are there any changes? Closing vote. Vote closed. 56 aye, 2 no, 4 excused.
Senate File 97, having received the affirmative vote of the majority of the members elected to the House, Senate File 97 has passed the House. So ladies and gentlemen, if we want to filibuster the rest of our time here and get nothing done, we're going to continue down the path we went down today. Just saying. Okay, the next agenda item we're gonna work on, so we're gonna try to get some concurrences done. First, I'm gonna sign some conferees. So conferees on Senate File number 32 will be Chair Washut, Crago, Provenza. Conferees on Senate File 66 will be Chair Walters, Larson Lloyd, Nicholas. We're at that order of business of request to concur with Senate amendments to House bills. The first message for our consideration is message number 402 on House Bill 188. Chairman Eklund.
Mr. Speaker,
Mr. Chairman.
I move message number 402 on House Bill 188. This is wolf depredation compensation, and I would ask for an aye vote on this concurrence. Most of the substantial changes the program from an ending date of 2026 to a ending date of 2028. There's also a word change, which word crafting contracts to agreement. The substantial change would, if there's money left over in this account, then the program will continue for a couple more years and we wouldn't have to revisit it. If the account runs out, then we probably would revisit and try to fill the fund again. But I'd ask for an aye vote on this amendment with the Senate.
We are voting on the motion to concur with Senate amendments to House Bill 188. A majority of the elected members is required. Chief Clerk, please call the roll.
Allemand? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Excused? Chadwick? Chestick? Klauston? Conrad? Crago? Davis? Eklund? Harrelson? Harshman? Heiner? Henderson? Hornock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrup? Oakley? Obermueller? O'Hearn? Olson? Ottman? Pendergraft? Penn? Provenza? Rodriguez-Williams? Sherwood? Singh? Slagle? Smith? Stith? Storr? Strock? Stivar? Tarver? Trujillo? Walters? Ward? Washut? Western? Excused? Winter? Wiley? Yin? Zwanitzer Dan? Zwanitzer Dave? Speaker Summers? Are there any changes? Any changes? Closing vote? Vote closed. 57 aye, 3 no, 2 excused.
By your vote, you have voted to concur with Senate amendments to House Bill 188. The next message for our consideration is message number 404 on House Bill 195. Chairman Nicholas.
Thank you, Mr. Speaker. Ladies and gentlemen, I would move message number 404 on House Bill 0195. This is the American Rescue Plan Act, so the ARPA dollars, and ask for your no vote, that we do not concur. Ladies and gentlemen, basically, the good body down the hall modified our appropriations by adding and subtracting. And if you add up the total addings and subtracting, it's about almost a $30 million difference from our position from their positions. And so I think we definitely need to have it go down the hall and have a discussion on where these ARPA dollars go.
We are voting on the motion to concur with Senate amendments to House Bill 195. A majority of the elected members is required. Chief Clerk, please call the roll. 195, Chief.
Allemand? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Klauston? Conrad? Crago? Davis? Eklund? Harrelson? Harshman? Heiner? Henderson? Hornock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrup? Oakley? Obermueller? O'Hearn? Olson? Ottman? Pendergraft? Penn? Provenza? Rodriguez Williams? Sherwood? Singh? Slagle? Smith? Stiff? Storer? Strock? Stivar? Tarver? Trujillo? Walters? Ward? Washut? Western? Excused? Winter? Wiley? Yin? Zwanzer Dan? Zwanzer Dave? Speaker Summers?
No.
Are there any changes? Oakley? Closing vote? Vote closed. 2 aye, 59 no, 1 excused.
By your vote, you have voted to not concur with Senate amendments to House Bill 195. The conference committee will be Walters, Chair, Sherwood, Nicholas. The next message for our consideration is message number 409 on House Bill 64. Chairman Harshman.
Thank you, Mr. Speaker. I move message 409, concurrence request on House Bill 64, and urge your no vote. Your no vote. This was a cap fin bill worked on over the interim. This provision that was put in the bill was actually not discussed and was just put in as an amendment on the other side. So I think we got to get together and visit a little bit. So thank you. Urge your no vote. Stand for any questions. Thank you, Mr. Speaker.
We are voting on the motion to concur with Senate amendments to House Bill 64. A majority of the elected members is required. Chief Clerk, please call the roll. 64 on this one, Chief, 64.
Allemand? Allred? Andrew? Angelos? Oh, sorry. Sorry. Allemand? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Clouston? Conrad? Crago? Davis? Eklund? Haroldson? Harshman? Heiner? Henderson? Henderson? Warnock? Jennings? Knapp? Larson Lloyd? Larson Lloyd, no. Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrup? Oakley? Obermueller? O'Hearn? Olson? Ottman? Ottman? Pendergraft? Penn? Provenza? Rodriguez Williams? Sherwood? Singh? Slagle? Smith? Stiff? Storer? Strock? Stivar? Tarver? Trujillo? Walters? Ward? Washut? Western, excused. Winter? Wiley? Yin? Swannsor Dan? Swannsor Dave? Speaker Summers? Are there any changes? Davis, no to aye. Brown, aye to no. Further changes? Closing vote? Vote closed. 20 aye, 41 no, 1 excused.
By your vote, you have voted to not concur with Senate amendments to House Bill 64. The conference committee will be Harshman Chair, Larson Lloyd, and Nicholas. The next message for our consideration is message number 410 on House Bill 108, Chairman Newsom.
Thank you, Mr. Speaker. I move message number 410 for House Bill 108, the sale of THC vaping devices and edibles to minors prohibited. The changes made in the Senate, some of them were just kind of more clarification of the definitions of the controlled substances that were considered under this bill. The biggest change was that they deleted the age 21 and made it 18. But checking with the sponsor of the bill, he would like to suggest concurrence. So an aye vote would be preferable. Thank you.
We are voting on the motion to concur with Senate amendments to House Bill 108. The majority of the elected members is required. The chief clerk will please call the roll.
Ellamand? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Clauston? Conrad? Crago? Davis? Eklund? Haroldson? Harshman? Heiner? Henderson? Hornock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrup? Oakley? Obermuller? O'Hearn? Olson? Ottman? Pendergraft? Penn? Provenza? Rodriguez Williams? Sherwood? Singh? Slagle? Smith? Stiff? Storer? Strock? Stivar? Tarver? Trujillo? Walters? Ward? Washit? Western, excused. Winter? Wiley? Yin? Swannsor Dan? Swannsor Dave? Speaker Summers? Are there any changes? Are there any changes? Closing vote? Vote closed. 59 aye, 1 no, 2 excused.
By your vote, you have voted to concur with Senate amendments to House Bill 108. The next message for our consideration is message number 412 on House Bill number 33, Chairman Northrup.
Thank you, Mr. Speaker. I move message number 412 to House Bill 33 and ask you to not concur. The good friends down the hall here have made a few amendments to it, one of which, this is the bill, I better probably bring you up to speed. This is the bill on school finance career technical education grants. And what they did is they took out the matching funds and that portion of that would allow people to be able to contribute to that if they wish to. And then they turned, also took the preference awards away, and we just would like to go down and make sure we can come to some kind of agreement with them. Vote no.
All right, we are voting on the motion to concur with Senate amendments to House Bill 33. A majority of the elected members is required. The chief clerk will please call the roll.
Ellamand? Allred? Andrew? Angelos? Banks? Bear? Berger? Brown? Burkhart? Byron? Chadwick? Chestick? Clauston? Conrad? Crago? Davis? Eklund? Haroldson? Harshman? Excused? Heiner? Henderson? Warnock? Jennings? Knapp? Larson Lloyd? Larson JT? Lawley? Locke? Nyman? Newsom? Nicholas? Nemec? Northrup? Oakley? Obermuller? O'Hearn? Olson? Ottman? Pendergraft? Penn? Provenza? Rodriguez Williams? Sherwood? Singh? Slagle? Smith? Stith? Storr? Strock? Stivar? Tarver? Trujillo? I'm sorry, repeat. Walters? Ward? Washut? Western, excused. Winter? Wiley? Yin? Zwanzer Dan? Zwanzer Dave? Speaker Summers?
No.
Are there any changes? Provenza? Aye to no. Further changes? Closing vote. Vote closed. 10 aye, 50 no, 2 excused.
By your vote, you have voted to not concur with Senate amendments to House Bill 33. Conference committee will be Northrup Chair, Lawley, Brown. Chief, is that the last concurrence? Do we have any messages from the Senate? I did messages from the Senate.
Message 407, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 38, Wyoming National Guard member referral. Ayes 24, noes 7. Message 408, Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 59, Wyoming National Guard tuition benefits. Ayes 23, noes 8. Message 409, Mr. Speaker, House Bill 64, Legislative Stabilization Reserve Account Obligations. The House bill listed above passed on third reading in an amended form by the vote indicated. Ayes 31. Message 410, Mr. Speaker, House Bill 108, Sale of THC vaping devices and edibles to minors prohibited. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 30, noes 1. Message 411, Mr. Speaker, House Bill 144, Senior Citizen District Programs and Services. House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 17, noes 14. Message 412, Mr. Speaker, House Bill 33, School Finance Career Technical Education Grants. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 27, noes 4. The Senate respectfully asks the House to concur by adopting the listed amendments. Sincerely, Ellen Thompson, Senate Chief Clerk.
Reports from standing committees.
Senate File 146, sponsored by Appropriations, State-Funded Capital Construction, an act related to state-funded capital construction. Mr. Speaker, your committee number 2, Appropriations, to whom is referred Senate File 146 engrossed. State Fund Capital Construction, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman. Senate File 153, sponsored by Senator Boner. Election Security, an act relating to elections. Mr. Speaker, your committee number 2, Appropriations, to whom is referred Senate File 153 engrossed. Election Security. Respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Walters, Zwanitzer. Noes, Representative Sherwood. Excused, Representative Stith. Representative Nicholas, Chairman. Senate File 120, sponsored by Senator Barlow. Restoration of Civil Rights, an act relating to crimes and criminal procedure. Mr. Speaker, your committee number 2, Appropriations, to whom is referred Senate File 120 engrossed, Restoration of Civil Rights, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman.
All right. We got any enrolled acts to sign? All right, yeah, we're gonna suffer through everything if we have to stay here a while. We're at that order of business as signing enrolled acts. The first enrolled act for our consideration is House Enrolled Act number 60. The reading clerk will read the enrolled act.
House Enrolled Act number 60 being original House Bill 118, an act relating to volunteer firefighter, EMT, and search and rescue pension account, specifying distribution of fire insurance premium taxes to the account, providing an appropriation and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign House Enrolled Act number 60 being original House Bill number 118. I have so signed. Congratulations, Chairman Newsom. The next enrolled act for our consideration is House Enrolled Act number 61. The reading clerk will read the enrolled act.
House Enrolled Act number 61 being original House Bill 81, an act relating to medical assistance and services, amending the Wyoming Private Hospital Assessment Act to include healthcare providers affiliated with a hospital and a psychiatric residential treatment facilities, increasing permissible administrative fee amounts, increasing assessment amounts, authorizing the Department of Health to modify payment or qualification provisions as specified, authorizing the Department of Health to negotiate with the United States Department of Health and Human Services as specified, making conforming amendments, providing appropriations, authorizing an additional position, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign House Enrolled Act number 61 being original House Bill number 81. I have so signed. Congratulations, Representative Larson Lloyd. The next enrolled act for our consideration is House Enrolled Act number 62. The reading clerk will read the enrolled act.
House Enrolled Act 62 being original House Bill 67, an act relating to motor vehicles, providing for a decal designating a woman veteran to attach to a veteran's special license plate, making clarifying amendments, providing for a decal fee, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign House Enrolled Act number 62, being original House Bill number 67. I have so signed. The next enrolled act for our consideration is House Enrolled Act number 63. The reading clerk will read the enrolled act.
House Enrolled Act Number 63, being original House Bill 59, an act relating to Defense Forces and Affairs, extending existing educational assistant benefits for the Wyoming National Guard members in exchange for additional services commitments, allowing transfer of educational assistance benefits to spouses and dependents, correcting terminology, providing appropriations, authorizing a full-time position, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign House Enrolled Act number 63, being original House Bill number 59. I have so signed. The next enrolled act for our consideration is House Enrolled Act number 64. The reading clerk will read the enrolled act.
House Enrolled Act Number 64, being original House Bill 38, an act relating to Defense Forces and Affairs, creating the Wyoming National Guard Member Referral Incentive Program, authorizing monetary incentive bonus payments as specified, providing definitions, requiring an annual report, providing a sunset date for the program, providing an appropriation, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I am about to sign House Enrolled Act number 64, being original House Bill number 38. I have so signed. Any sentence? Well, Chief, do we have anything to clean up? Because I don't think we're going to do general file. Okay, Mr. Majority Floor Leader.
Mr. Speaker, I move the House will adjourn until 10 a.m. tomorrow, the 24th day of February, 2023.
Committee announcements. Chairman Northrup.
Thank you, Mr. Speaker. Your committee number 4 will be meeting upon adjournment tonight. We are going to hear Senate File 132, study of, I'm sorry, that's not right, 133, student eligibility in interscholastic sports. And then tomorrow at noon recess, we will be working on Senate File 132, which is study of K-12 education program.
Chairman Zwanitzer.
Thank you, Mr. Speaker. Your committee number 10, Labor, Health, and Social Services, will meet tomorrow morning at 8:30 in E3 to talk about forced microchip implantation prohibitions. You're all welcome to join.
Chairman Washit.
Thank you, Mr. Speaker. Your committee number 1 will meet at 8 o'clock tomorrow morning in our normal room. We'll consider Senate File 167 in gross domestic violence protection hearings and Senate File 152 occupational therapist criminal history.
Chairman Burkhart.
Thank you, Mr. Speaker. Your committee number 9, Minerals Business and Economic Development, will meet tomorrow morning at 8 a.m. In an executive session. No bills will be considered.
Vice Chair O'Hearn, are you just hanging around the mic or you got something? Hanging, all right. Anything else? All right, you have heard the majority floor leader's motion. All those in favor say aye. Aye. All those opposed? Motion carries. We stand adjourned until 10 a.m. tomorrow, February 24th, 2023.